Good morning, everybody. We are starting cases back up again today. We've got some good ones this week. Today we're going to be looking at Chatrie versus US and Monsanto versus Durnell. So the Monsanto case is a Roundup case. If you've never heard of the Roundup issues, it's a product for weed killer where people got cancer. I've actually had 2 family members that had that happen to them. We'll be watching that at 10:30. We're going to be starting with Chatrie versus US, which is about geofence warrants. I know everybody's excited. Geofence warrants, like cell phones, that's what we're talking about. Did this violate the Fourth Amendment in this case? And even better, should they exclude the evidence? So I'm going to start playing. Oh, even better. So it's already starting. We're waiting on it. Usually they start within about 5 minutes. If you got questions, you can pop them in the chat. Do the likies and the follows and all the shits, but we're going to be watching both cases this morning. Chatrie versus US, geofence warrants. Did it violate the Fourth Amendment? And then after that, we're going to be doing the Monsanto versus Durnell. This is just a special interest case for me. You don't have to stay and watch it. I will watch it with y'all, though. I'm very interested. I did have 2 family members who do have cancer because of Roundup, so this is just a case that I am interested in, but we should get going here pretty quickly. Did you see the Virginia court approved 10-1 map? I knew that a judge had said something, but I haven't seen what I started. I've had a horrible cold for the past few days, so I've been a little off and on with the news and everything. Been getting a lot of sleep and resting over the weekend, but hopefully we're ready to get back in it. Y'all will see me eating this morning, so if it bothers you, I don't know what to tell you, but I'm hungry and I've got 2 cases today. So we will get there soon. But Chatrie versus US is first. It should be starting in just a few minutes. Did the geofence warrant violate the Fourth Amendment in this case? And that's always a question we have to ask ourselves. How far can these warrants go? Did they have probable cause? It's always fun, and I love hearing about the background on the cases if they go through it. Sorry, I didn't try to do that, but any hoodle. No, Dobby, I didn't hear about that, but if you want to send me a link, I would be happy to look at it. Should be starting soon though. I think Attorney Dye said she was going to try to come by in a little bit, so we're just sitting here chilling, listening. We're good background. If you're on your workday, I hope your workday is starting out wonderfully. And we're good to chill and just listen to in the background. Not much of a debate. We're just talking law and nerding out in here. If anybody has any questions, drop them in the chat now as soon as this gets going, and I'll try to get to them or answer them later. But we should be here soon, guys. Probably start in about a minute or so. They're supposed to start at 9, but my ass, if you've ever worked in the court system, you can appreciate that absolutely nothing runs on time. Oh, thank you. Geofence warrant. I'm trying to think of the best way to explain that. You know, when you have a cell phone, geofence. That's what the warrant is on. That's the easiest but best way to explain it, because sometimes they vary in what they are. Hold on, let me get you 1 second. A case about police access to geofence data, a digital record of a person's location. This case could serve as a landmark intervention in the Fourth Amendment doctrine in the digital age, or a more limited adjustment of those rules. The court could either greenlight or restrain reverse searches, a key investigative tactic of the digital age. Either way, this is probably the most important case on digital privacy that the court has heard in years. I mean, can police just have access to this? It's certainly an interesting perspective to look at. I like the idea that they're questioning this because should they? Should there be a more stringent criteria? Hello. I'm so happy all of you are joining. As soon as we get going, if you've ever joined my lives before, you know, as soon as they get going, I'll shut the hell up and I'll just yell in if I have a comment. But sorry guys, I've been sick for the past few days and I am eating on live, so if it bothers you again, I don't know what to tell you other than don't look maybe. However, if you are bothered by my voice going over oral arguments, as always, I will go over this with everybody. You are more than welcome to go to SCOTUS and watch this yourself.
We'll hear argument first this morning in case 25-112, Chatrie versus United States. Mr. Unikowski.
Mr. Chief Justice, and may it please the court. The government conducted a search of petitioner's location history, and the warrant that purported to authorize that search violated the Fourth Amendment. The government conducted a search. The court should hold that people have a property interest in their data, in their accounts on the cloud. Location history has the core attributes of property. Petitioner had a right to exclude, to control, and to destroy. Additionally, petitioner had a reasonable expectation of privacy in his location history, given both its sensitive and revealing nature and the fact that it was stored in his password-protected account.
That's
right. The warrant
right.
violated the Fourth Amendment. The warrant authorized the government to direct Google to search every single person's account to find those people who were within the geofence. That is a general warrant. Even if the search materialized only when the data was found and exposed to the police, the warrant would still be unconstitutional because there was not probable cause to search the virtual private papers of every single person within the geofence merely because of their proximity to the crime. Finally, at Step 2 and Step 3, the search violated the Fourth Amendment because the warrant gave the police unlimited discretion to decide who to search while casting Google into the role of magistrate. I welcome the court's questions.
How exactly did the warrant violate petitioners' rights at the Fourth Amendment rights at Step 1?
So at Step 1, we understand this warrant to have authorized—
I thought it was anonymized at Step 1.
That's true. So from our perspective at Step 1, we believe that there was a search of every single account, and alternatively, at a minimum, there was a search of the accounts of all the people whose data was exposed to Google, but either way, we view that as a search that the warrant authorized. But let me specifically answer your question about anonymity. We view the anonymity in this case as both irrelevant to the Fourth Amendment analysis and also rather illusory. So first of all, I don't think anonymity matters because I think a search is a search even if you don't know the target of the search. Like if you go to a bank and you break open a safety deposit box— I'm sorry, Your Honor, do you have a question? No. If you go to the bank and break open a safety deposit box, even if you don't know who owns the box, if you inspect the papers, I still think that counts as a search. As well, as a practical matter, anonymity is somewhat illusory because one's movements within the geofence often functions as a kind of fingerprint. You can figure out who the person is based on a fairly small amount of movements. In this very case, our expert was able to identify 3 purportedly anonymous people via a close analysis of their movements as well as some public records.
So if you don't want the government to have your location history, you just flip that off. You don't have to.
Not true. That's not how it works.
On your phone. So what's the issue?
I take the point that you can flip it off, but I guess I just don't agree that one should have to flip off one's location history as well as other cloud services to avoid government surveillance. I mean, by the same token, you don't have to send email. You can flick that off as well, but that doesn't imply that you're implicitly consenting to the government searching one's email.
Well, not implicitly consenting, but the only reason the
government
this
has
is a
access Google
to this
geofence. Sorry,
is because you've decided to make it public to the extent it can be accessed by people any number of ways. In other words, people can use that information, not simply law enforcement.
Well, I guess
it's like if you don't want them to peer into your window, you can close your window or the shades.
I take the point, Your Honor, but I guess I'd respectfully disagree with that assessment for a couple of reasons.
Yo,
so first
everybody.
Of all, I think you could say the same thing about
I'm sick
sending
today,
mail.
so I apologize.
You don't want the government to look in your mail. You don't have to send it and give it to the postal
Please
service.
tap the screen, share the live. This is geofence warrant.
But I think that one should be permitted to hand over data to a third party without assuming the government is going to look at it, especially since it's true in this case petitioner was convicted of the crime, but geofence warrants mostly ensnare innocent people. In this case, you had 19 people within the geofence whose data was exposed, as well as 2 other devices whose actual identity was exposed. And Google received 9,000 of these warrants in 2019.
19
so I don't
people
think
within this
innocent person
warrant.
should have to shut off these services as a condition of not being
Do
surveilled.
the numbers make a difference? Would it matter if only 1% of users enabled location history?
I don't think it should matter. The government has made a point about the fact that only 1/3 enabled it, but I actually don't think those matters really are significant. Because if you view a person as having, a property interest in the data, in other words, if you treat one's account as kind of a virtual safety deposit box, then I don't think it matters how many people have these virtual safety
Davo,
deposit
you're
boxes.
welcome
Even
up.
if it's
This
only
is
one, if
geofence.
the legal
This is your
relationship
shit.
to the data is similar to the legal relationship between someone who sends a package.
Mr. Unikowski, it's not just a question of shutting, it's not a question of shutting it off.
There's Alito.
It's a question of turning it on. And according to the government, your client had to go through multiple steps in order to turn it on. So he voluntarily disclosed to Google the information about where he was going to be.
So if I could make 2 points about the voluntariness argument that the government advances. So first of all, I actually don't think it should matter for Fourth Amendment purposes that there was voluntariness, because it's quite common for people to consent to putting their data in the cloud, in the sense of every time you send an email or you send a document, have a Google Calendar entry, all those things you're consenting it to sending it in encrypted fashion from your phone to the cloud. But I don't think that the consent merely to have your data stored in this virtual storage locker in and of itself is consent to disclose
Well,
to the government.
he not only turned it on, but had
So I'll tell you what I'm more worried about in this case here. I'm not as concerned about the client. I'm concerned about what did they say? It was 19 other people that got ensnared into this geofence that they even said that they were able to properly identify, 2 or 3 of them? That should be a huge concern to anybody. Even if you consent, you don't just have, at least in my opinion, you're not just turning over your right for the government to get your information just cause. That's my bigger issue here. I apologize. Let's get back into it.
Any reason whatsoever. I think that might be more pertinent to the property theory than the privacy theory, because on the privacy theory, the court said in the Byrd case that, terms of use aren't necessarily dispositive. They should look at sort of general expectations. I mean, maybe if it was like really flashing and saying, we are the government's partner, we give data to the government all the time, maybe that would result in a different analysis based on one's reasonable expectations. Under the property theory, it might be relevant because one of our arguments here is that the terms of the bailment are that Google could possess this information but couldn't necessarily turn it over. There was a strict privacy policy, so it wouldn't turn it over to advertisers.
That privacy policy, the terms of service, pretty much, and I'm paraphrasing here, we will respond to lawful requests from the government. I don't know whether one even needs to say such a thing. Right? I mean, it's anybody who gets a warrant, and a lawful warrant has to comply with it. And a bank, a doctor, a lawyer, anybody. So it doesn't seem to me to add a great deal to the analysis. And are the terms of service here materially different than they are for email and for Google Documents?
So as to the first point, I agree, and actually the U.S. Postal Service has the same provision in their terms of use. We'll comply with search warrants, but I think a search warrant is still needed there. And on the second point, no. The general language that the government will, that Google will comply with search warrants and that Google will, reveal aggregated information, like what's the most searched term of last year? It turns out it's YouTube, like that type of disclosure, that applies to all data that's stored at Google, not just location.
So if we were to rule that there was a voluntary exposure here to Google that allows the government unfettered access to it, that ruling would pertain to email.
That's correct. Essentially, all of your data on the cloud, which is kind of all of your data, if you use a computer, would be exposed to government searches without a warrant.
So where do you think voluntariness matters and where not? What you're suggesting is really that's the wrong question here. When is it the right question and when is it the wrong question?
So I think there might be a voluntariness issue when it's very clear from the interaction that you really are consenting to the other person doing whatever they want with it, such as when you give information to someone knowing that the someone is going to use it as a business record. So I think that the Miller case, for example, we're certainly not disputing the holding of Miller. And in the Miller case, the court explained that if you put a check into the stream of commerce, okay, so you give it to a vendor, and then the vendor gives it to their bank, and then their bank gives it to your bank, and it becomes their business record. You can't control it. They keep it for their purposes. You can't delete it. You have voluntarily put something into the stream of commerce and you've sort of given up control over it in the relevant sense. And so on that fact pattern, the court said that you have relinquished an expectation of privacy. And there's a similar holding in the Smith case. The court said that when you give your phone number to the phone company, you know it's their record. They're putting it on your phone bill. They're using it for all kinds of business purposes. It's exactly like it used to be when you just talked to a telephone operator. And in that case, you're not just giving someone information like you're mailing something, but you're like giving consent for them to treat it as theirs. And that's the fact pattern that I think the court has said that the voluntariness of that transfer of property is sufficient to say that you've given up your reasonable expectation of privacy as well as your property interest.
Mr. Unikowski, I'm struggling to understand why we are hearing this case, other than the fact that at least 4 of us voted to take it. 14 of the 15 judges on the en banc Fourth Circuit voted to affirm. 9 relied on the good faith exception. Unless you think that we're going to say something that convinces, that unless you think we are going to say no reasonable officer could believe that this was a valid warrant, or we're going to say something that will convince the judges on the Fourth Circuit to reach that conclusion, what you're asking for is an advisory opinion. That's number 1. This involves a Google feature that it doesn't exist any longer. That's number 2. It involves a warrant that is structured in a particular way. That's number 3. We are all free to write law review articles on this fascinating subject. But that seems to be what you're asking for. Asking for basically a
He's
law
such a
review
little
article
shit this
on
morning.
a subject that
Alito woke up on the wrong side of the flag.
Explored by our precedents.
So let me tick through each of those points, Your Honor. So first of all, as to the good faith exception, the court did not grant certiorari on that question, and so we didn't brief it. So all we'd ask for in this case is if the court finds a Fourth Amendment violation, to reverse and send it back to the Fourth Circuit to consider the good faith issue in view of this court's guidance. Now, I admit it's going to be hard for us on the facts of this case to say that the officer acted maliciously or that the legal issues are obvious. I think if there's anything obvious from the briefs in this case is that they're not obvious. We would make a different argument. We'd say that the Leon good faith exception applies to fact-bound challenges to probable cause determinations in a particular case and shouldn't apply where we're challenging a new and fundamentally different type of warrant. And if you look at Leon, there's some language in there that says that the exclusionary rule, even in cases of warrants, should be considered on a case-by-case basis, and exclusion is warranted in the unusual context where it would advance the purposes of the exclusionary rule. So we'd just like a chance to make that case in the Fourth Circuit with the benefit of the court's guidance. In terms of the issue that Google has discontinued the censor vault and has put the data onto people's phones, first of all, this was fully ventilated at the certiorari stage. I don't think that there's any surprises that are in the merits briefs in this case. I think this is an important subject because lots of providers store data, not just Google. There's something like 30 amicus briefs or 29 amicus briefs in this case, including by many of the titans of the tech world. And so I think a lot of people think that this case will have implications beyond these particular facts. So we'd urge the court to decide
It absolutely
the question on
will.
which it granted certiorari.
Well, we can affirm on any ground that would support the judgment and was raised below, and the good faith exception qualifies on all those points. So the fact that the court did not grant certiorari on the good faith exception does not preclude any of us from relying on that.
I'm not sure I agree. The court specifically declined certiorari on that question, so we didn't brief it. And we raised in our cert petition that we'd like the chance to argue that the questions are intertwined, and in view of a holding on the Fourth Amendment issue, we'd like to litigate the good faith issue. The court didn't grant certiorari. We didn't brief it. The government did have a section of the respondent's brief addressing the good faith exception, but adhering to the court's decision not to grant certiorari, we didn't respond in the reply brief except to ask for a remand. So,
well, that was your choice.
The court did not grant certiorari. We were reluctant
God,
to brief a
Alito is
question
on
which the
one
court
this morning.
specifically
What the
You're an
fuck?
experienced advocate. You understand that we can affirm on an issue that was raised below.
Dear
and we
people,
support the
Alito
judgment.
is on one, and he's
I'm
being
happy to argue the issue from the
such
podium, Your Honor. I'll just say
Come
one
up
word
here,
about it.
Law, I
think
miss
that
you.
that the premise of Leon is that it's not necessary to apply the exclusionary rule in a case of a fact-bound challenge to a probable cause determination in a particular case, because probable cause is litigated all the time outside the context of warrants. Whereas in an issue like this, a challenge to a fundamental new type of warrant, I do think litigants need an adequate incentive to litigate the constitutionality of such warrants, and the only way that'll happen happen is through the exclusionary rule. And there is some language in the Davis case that adverts to holding that in cases where you need an adequate incentive to litigate an issue, the court would consider applying the.
And Mr. Unikowski, isn't there also a pretty significant
Apparently law.
split, even within the Fourth Circuit, over the issue of whether or not there was a search in this context? I mean, my understanding is that the Fourth Circuit split evenly, 7-7, on that pretty significant issue.
If you need me to
That
pause,
is
just
correct.
let me
It
know.
was 7-7 with one judge declining to reach the issue. So obviously there's some important issues that go well beyond the particular facts of this case. And there's also some important issues in terms of the constitutionality of the warrant that go well beyond the facts of this case.
Counsel, I just want to button down some of your answers. The privacy policy
Sotomayor.
that the person is giving consent to would affect, you said internet, but it would also affect Google Photos, which have to do with what photos you take and store in your device, correct?
Correct.
Google Documents, what documents you store.
Correct.
Google Calendar, your entire calendar. If this is consent, that means the government can seek those documents for any reason, not just the commission of a crime, or no reason, correct?
Correct. It would not be a search, so no search warrant would be required.
So that means the government, a police officer, randomly, who decides, I don't like that person, let me just go look at their life to see if I can find the crime, that would be okay.
There might be some constraints under the Stored Communications Act, but as far as the Fourth Amendment is
Right,
concerned,
but
no.
that's not at issue here.
Correct.
All right. And that wouldn't be for other things,
Correct.
for some of these things, like calendar entries.
So there might be a question as to whether calendar entries are protected as a statutory matter, but again, we're here under the Fourth Amendment.
And
so
we
that's-
can't ignore today that the district court made findings that the consent here was not necessarily voluntary.
There are findings that at midnight, when you're saying, yes, I'm in, to try to get your phone to work correctly, that may not be a consent to the government searching
And
your
there's
phone.
certainly Google documents that show that it's very hard, and if not opaque,
Putting stuff
to figure out
on
how to turn these things off.
products
correct?
that we can't really live
Now,
without at
let's go
this
to
point
your,
shouldn't be
your
some
general
form of
warrant
consent.
theory.
I'm sorry.
I understood at the founding a general warrant was, I have a crime, and a magistrate permitting you to go willy-nilly anywhere you want, to anyone you want, to search them. I thought that was the purpose of general warrant, correct?
Yes.
That's not what this does. This identifies a place, a crime, a limited time frame, but a time frame. So it's not a general warrant in its historical sense. Why isn't this closer to the warrants that we've permitted with beepers, where we don't have a person or necessarily a place in mind, but we have a location and general things? Why isn't that more consonant with Berger, Zucker, Caro, those lines of cases? And that didn't identify a person, but it identified a crime, a place, and the nature of the unlawful conduct that we were looking for.
Sure. So let me say a few words as to why I think this should be considered a general warrant, and then a few words about why the warrant was defective, even if you disagree with me on the first few words I say. So first of all, I think the right way to think about this search is to say, one, that Google, because it received a search warrant, was acting as the agent of the government, and two, that Google really did search every single person's virtual private safety deposit box. So as to the first part of that, this court has said that when a third party is acting with the encouragement, endorsement, or participation of the government in executing a search warrant, that third party is...
Could I pause you there?
Yes.
It wasn't Google doing it, it was a filter doing it.
Well, it was...
I mean,
What?
the filter is not the government, it's not even Google, it's a mechanical item that sorts.
Oh,
It's
fuck
code.
my life.
It's code made by
So
Google.
how could that be a search? Seems to me that the
Thank
only
you, Law.
search would be handing it over to the government.
So let me say a few
Step
words...
one, basically.
Sure. Let me say a few words about that and then say why, even if the search is the handing over, the warrant is still defective. So as to the first part, you're absolutely right. There's not a
These
human being
motherfuckers
sifting
are
through
too
500
old
million
to be
people's
doing
accounts.
this.
That
I
would
said
take an
what I
extremely
said.
long time. At the end of the day, it was a piece of software that was going through every account, piercing, from our perspective, every virtual safety deposit box and checking inside to see whether the person was there that day. So I still think that when you're using software to search someone's phone, which is how any kind of digital search operates today, that's still a type of search because it's using a tool in order to detect information. And it's true that it's a tool, it's not the human being that's looking at it, but it's still a human effort to pierce a private area in order to find something that's there.
Would that mean all database searches are searches for Fourth Amendment purposes?
Absolutely not, Your Honor. That is not our position. I think this is a unique case because Google's sensor vault really is structured like a row of virtual safety deposit boxes, individual accounts. It's indexed by account, which means you have to put in your own credentials to get to your account, and that doesn't get you to anyone else's. So it's exactly like a bank with safety deposit boxes, except it's in the cloud.
So does everything depend on how a company organizes its information?
I don't think everything depends on that. I think that this is a unique case because the fact that Google organizes its data that way is not some kind of arbitrary engineering decision. It really is essential to the security of a system with lots of private accounts to index them by account. So the technologist's amicus brief, I think, has a good analogy here. It says that it's not arbitrary that a hotel divides different people into different rooms as opposed to stacking all of the bunk beds in the lobby. Like a hotel, which divides people into different places, it's logical to have walls between them. And in this case, there's virtual walls as opposed to physical walls. But I don't think that the fact that Google could have constructed its system in a completely different and, from our perspective, inappropriate way should affect the analysis. I'm sorry.
Sorry, finish, please.
No, please go ahead.
I was just going to say, this seems very complicated from the user's point of view. Frankly, I have no idea how my data is stored and whether it's in these virtual lockers or not. And I guess one question
It's almost
that I
like
have
people
for you
may
is
not know what they're consenting to when the government can't even decide.
One way to think about this case is that, listen, our physical intrusion cases, our property cases require a physical intrusion, and CAT set us off on this course that when we're talking about technology, we think about it in terms of reasonable expectations of privacy. And I am, frankly, a little bit nervous. I mean, I think the government makes this point well. I'm a little bit nervous because this is very complicated, right? Figuring out how bailments apply, what the property interest in this data is. Why not just think about this from the perspective?
I'm going to stop right there. I already hate that line. It's complicated. It doesn't fucking matter. It's complicated is not a good enough reason that people's Fourth Amendment rights don't apply, or I don't really know how we set this out, is not a good enough reason not to have a reasonable way to look at people's Fourth Amendment rights here. Like, I don't know if maybe I'm just going off in a different way with this, but this bugs me when they use this kind of language. I don't know. You can weigh in if you want, Law, and then I'll restart.
Yeah, I do think she's hitting on a legitimate point, though, is that what constitutes the search is going to be the hard line here is, and I like this argument about the digital safety deposit boxes, because there's case law that says you can't go to a bank with a search warrant to search their safety deposit boxes because that's not particularized enough. So I think that that's good. But I think where they're trying to establish the line is the act of Google filtering these geolocation data and then making it available. Is that the search, or is it the government's request? And if it's just the government's request to data that Google's already categorized, does that actually implicate the Fourth Amendment? So I think that Coney Barrett's trying to get a defined line here, especially regarding what is the line that Google sets that could potentially implicate the Fourth Amendment.
I gotcha. Thank you.
Of the 9 people who are of greatest interest to the government at step 1, it followed those people around outside the geofence at step 2. And I think that all of those considerations create significant privacy implications, even though it's true the initial geofence was just an hour.
But you can't raise the Fourth Amendment issues or the Fourth Amendment rights of the other people who might be captured in the geofence. We're really just talking about your client's Fourth Amendment rights, right? I mean, because you keep pointing out, well, this swept in a lot of innocent people, sure, but really it's your client's Fourth Amendment rights that we care about here.
That's true. I just think, broadly speaking, when we're considering the privacy implications of the rule and reasonable expectations of privacy, I just think it's relevant, what the court's rule is, how this is going to affect, third parties. I understand it's just petitioners' rights at stake, but even staying laser focused on petitioner, this was a law enforcement tool that allowed the government to determine where petitioner himself was at any point in the past.
Mr. Eunuch?
Yes, sir.
Oh, sorry. Are you done?
Only in public places, though.
Well, the government has taken the position in its brief that even if you're in your own house and a geofence warrant is used, the government has a footnote suggesting that there wouldn't be a constitutional violation either. Obviously, this case did involve a bank. I acknowledge that. Although, just one other word, because of the error bars, because of the confidence intervals in some of these estimates, actually, those confidence intervals may have encompassed people's homes. And in fact, 3 of the people within the geofence went to their houses and were possibly identified by our expert.
So I wanted to invite you to finish your answer to Justice Sotomayor when you said you tried to defend the general warrant analysis, and then you said, even if you don't agree with that, I have another point. But before you do that, let me just home in for a second on the general warrant analysis. If we
this is Jackson,
take
sorry.
Justice Barrett's point that this is really about reasonable expectation of privacy, what about the initial sorting intrudes on anyone's reasonable expectation of privacy?
I guess I just think that if I have, information in a physical storage, safety deposit box, I guess I think that my expectation is that no one's going to look inside for any reason, even if a tool is used, like, the Kylo tool, the thermovision, for any reason. If I have stuff inside, people won't look at it in order to conduct a law enforcement investigation. And I understand the intrusion at step 1 was fairly limited. It was just a computer zipping past all these accounts, just checking quickly whether they were in a particular place. But, cases like Jones say that even a very small trespass is enough. But I see my red light is on. If I could just answer Your Honor's second question.
Well, why don't you wait till we get back to that? It seems to me that the exigent circumstances exception
Roberts.
Could well expand if you're right.
Thank you. I was
obviously,
chewing.
You have situations where somebody in this particular crowd has snatched a child or was involved with somebody who snatched a child. In those situations, I suppose you agree that you don't have to go through a warrant process, but can access the information under exigent circumstances?
I do. The court made that very clear in Carpenter. I mean, this warrant was sought several weeks after the crime, and so any exigent circumstances, I think, argument would have gone away. Our position today is not intended to undermine any well-recognized exception of the warrant.
Well, my question is whether intended or not, whether it could be used to expand it a great deal. I mean, what's exigent can be expanded if, in fact, it makes sense. It's when you have, you don't have this much access, doesn't do any good to say, you have to search to find out who all these people are. But if the push of a button, you can find out who they are, that might give you more opportunities.
Pause for a second.
To avail yourself of the exception. I don't know which way that cuts, but it does seem to me that it might.
All right. If he's good, he's going to concede the exigent circumstances argument because that's not really before the court and doesn't apply in this case. So if he's smart, he'll say that that may be, and that might be a case for a different day, but before us in this case, this, clearly no exigent circumstances. So I'm very curious to see what his response is going to be. I just wanted to stake my flag there.
No, I got you.
Justice Kagan asked you whether this would apply to all
This motherfucker.
searches.
Alito dog pile?
Digital searches.
He is on one
go
this
back to the
morning, and I
pre-digital
can't even.
Did we skip ahead?
It's not at all uncommon.
Yeah,
It was
well,
not
it's
at all
live, so it
uncommon
jumps.
Oh, I missed his answer then. Oh,
grand
sorry.
jury to issue
We'll find it in a minute. Hold on.
requiring a company to turn over a category of particularly described documents, but that for the company to find those documents required a search through a vast store of hard copy documents. What's the difference between this situation and that situation?
So I don't think a grand jury subpoena or any kind of subpoena would have been constitutionally permissible in this case.
Well, I know you say that, but what is our test for determining when a grand jury subpoena violates the Fourth Amendment?
So I think there's 2 circumstances when it does. One is when the holder of the documents are really a bailee of someone else's documents. So one example would be a grand jury subpoena directed at the Postal Service or FedEx, asking it to open every single package or piece of mail to find a piece of data. Or,
when it's the company's own documents.
Right. So when it's so of course, as we've said, we don't think
kill
that's
me.
this case. But when it's
I
the
hate
company's
this
own
guy.
documents, I just go back to the test in Carpenter, which is there's a narrow category of cases in which a person will have a reasonable expectation of privacy in business records held by a company, and in that category of cases, the subpoena is unconstitutional.
Well, I'm sorry, go ahead.
No, please.
Well, in Carpenter, what seemed to be a very important feature, I think maybe a dispositive feature, was that the information that was sought was information that the user of the cell phone had no choice but to disclose, because the cell phone tower location is an indispensable feature of actually using your phone. That is not the situation here.
I take the point that it's possible to function in society without having location history enabled, although, it's actually quite hard to function without having anything in the cloud. I'd say
Why is he
virtually
so
everyone in
angry,
this room has
Law?
at least something in the
Well, but we're not talking about everything in the cloud. We're talking about location history.
Right. It's actually quite hard.
On an Android phone, where you have to take a number of steps in order to disclose it. So you have to choose to disclose it.
I take the point that you
Not
have to
necessarily.
place time in order to enable location history on your Android phone or any other type of phone. But first of all, if you agree with us that this is a personal record and not a business record, that argument just doesn't matter, because you make the choice to enable email or put documents or photographs into the cloud. You're choosing to send that photograph, but that choice shouldn't undermine the Fourth Amendment protection, just like your choice to put something in the mail.
Well, you think this is
That's what I've
not
been
a
fucking
commercial
saying.
record? Why do you think Google compiles this, keeps this information? It does it so it can sell
So
advertisements.
it doesn't disappear,
Google itself
you
takes the
fucking
position that these are
moron.
not business records. I understand it's just a third party's view, but it's unusual for a company to refuse to say that something's its own records. Unlike with CSLI, you have total, as Your Honor said, you can turn it on, you can turn it off, you can delete all of it anytime you want, you can delete part of it. It's really unlike something like CSLI, in which you have the business keeping the records for its own purposes.
Counsel, I'm sorry, are you through?
You're on.
I want to go back to Justice Barrett's. If you're not through, Sam, I thought you were through.
Go ahead.
To go back to Justice Barrett's question. When the police are searching or asking for a search result, there's no way to predict whether they're going to invade your privacy, correct?
That's right. Searches are determined ex ante.
Regrettably, because people take their phone now everywhere, including, I suspect, some people to the bathroom, you really have no idea.
Don't be a hater
what
on bathroom
information,
phones,
private
Sotomayor.
information, because it'll follow you to a brothel, it'll follow you to a cannabis shop, it'll follow you to just about anywhere where there's a reasonable expectation of privacy, correct?
Yes.
And so it really doesn't matter. I don't think the time is important, correct?
I agree with that.
So whether it's a minute that you're searching for or
It's not the true
6
socials
weeks,
on the crapper
it's not
law.
the time that's at issue. It's whether or not private information in which you have a reasonable expectation of privacy will be sought, correct?
Yes.
That's why Justice Scalia said it didn't matter for Fourth Amendment purposes to search the heat waves emanating from your house, because though it's not giving out private information, you can't know in advance what it's going to disclose, correct?
Yes.
All right, now let's go to that more important part of the question that Justice Barrett asked, which is, we didn't answer this question in Carpenter, but I don't see how its logic made time the defining characteristic. Could you explain why not?
Sure.
It would seem to me that particularity has nothing to do with time. It has to do with the relationship of time to the circumstance that justifies the need.
Right. So there's two questions about time, one of whether there's a search at all, and then the second question of whether the warrant was sufficiently particularized. So as to the first question, I don't think the time period should matter as to the search, because I don't think the court should be in the business of drawing lines between 7 days and 2 days and 24 hours, especially since the government gets to choose the time interval. So 2 hours at a place selected by the government really can reveal a lot.
Sure, but the government in setting forth the warrant has to give a reason for why that 2 hours is reasonable.
Of
correct?
course. So that gets to the question of particularization, and that goes to the warrant. And I would like to say a few words about what the court should do if it doesn't agree with me that this is a general warrant in which all tens of millions of people were searched. We still think there is a Fourth Amendment violation because there wasn't probable cause to search all 19 people within the geofence merely because of their proximity to the crime. I get the fact that a time period was specified.
Well, Google itself said that to them, and I don't know why why we would say it's okay to rely on Google to do that. They moved it from 19 to 9, wasn't it?
That was at step 2, Your Honor.
Oh, step 2. Okay.
Yes, but at step 1, 19 people's information was exposed merely because they were near the scene of the crime. And so I don't think that the problem, I understand that the warrant specified a time period, but the particularity requirement in the Fourth Amendment requires particularity as to what is searched. And I don't think that there is, certainly I don't think there's particularization here when the warrant just said, whatever unspecified number of people are in the proximity of the crime, those are the people to be searched. I don't think that's a particularized description of what is to be searched.
Is he representing all 19
people? I think there's a probable cause problem here because the fact that someone's near the crime doesn't create probable cause to search their diary, and we view this as the functional equivalent of a search of their diary.
Justice Kagan?
Can I ask you to explain that a little bit more? Because you were saying that this was the answer if we rejected your categorical argument. Is that correct?
If you reject our argument that there's been a search of millions of people, then yes.
Yeah, but functionally, isn't that argument going to be the same? In other words, it's going to prevent the government from doing this kind of search in order to get these 19 people?
Not necessarily. So sort of a narrower argument would be that if there's probable cause to really believe that every single person in the geofence has relevant information, then that's a stronger case for the government. So that might come up, for example, suppose there's a murder in the woods and it's 3 a.m. and there's one criminal and one victim, and you draw a circle around that, and there really is probable cause to think that every single person in that circle is either the murderer or the victim, then maybe the government can say there's probable cause that every person whose data is exposed to the government in that case will have relevant evidence. That's not the case here, where the geofence encompassed the bank and the church. And in fact, most of the 19 people were just sitting at church the whole time. So that would be a narrower way to invalidate this warrant that wouldn't necessarily impugn all geofence warrants like this one.
Thank you.
Justice Gorsuch?
So if in this case the geofence had encompassed just the bank, perhaps?
Right. So, I mean, as the court knows, we still think there's a general warrant. We still think that everyone's storage lockers is being searched. And we also think there
might be probable cause to think that everybody in the bank might have some information.
Right. That's right. If you can draw it a small enough geofence at a small enough time interval that everyone there either committed the robbery or witnessed it, then you might say there's probable cause that everyone has relevant information. I still would say there's a particularity requirement. I'd still talk about a general warrant, but yes, that defect in the warrant wouldn't exist in that.
Right, and Google can track you down to several feet, right?
That's right, correct. 3 meters, Your Honor.
Yeah, and then in terms of the timing and on the search side that we've discussed, the fact that the government peeks in your mail for just a quick second.
Okay, I thought that,
looks through your safety deposit
thank
box,
you
your
for
hotel
clarifying
room,
because
or
I
your
was
diary
like,
for just a minute. That's a search, right?
Yes.
Under either property or a reasonable expectation.
That's correct.
Talk with me for a minute about the Stored Communications Act and the government's responses to your arguments.
So we believe that a warrant was required under the Stored Communications Act.
It is
we didn't
Monday,
file a motion to
Isaac.
suppress on that ground because suppression isn't an available remedy, but that may be pertinent to the question of a reasonable expectation of privacy because people have an expectation the government will get a warrant if there's a statute that requires the government to get a warrant, and there's also a private cause of action on the table. The government takes the position that possibly the Stored Communications Act doesn't require a warrant because the cell phone is a tracking device. I mean, if that's true, then anything that's transmitted from the cell phone into storage, your email if you're sending it from your phone or a photo or anything else, all of that would be information transmitted by a tracking device, and none of that would be protected. So I don't think that's a tenable way of getting around the Stored Communications Act. And so precisely because Congress has acted, and from our perspective, required a warrant, and in fact, in this case, a warrant was obtained, albeit one that we don't think complies with the Fourth Amendment, I think that weakens the force of the government's argument that we should defer to Congress because Congress has actually said that a warrant is needed here. And, implicitly, we think the Stored Communications Act requires a warrant that complies with the Constitution, and in this case, in our view, it did not.
How about the question of whether it's content versus a record?
So the government hasn't disputed that this is content, it's not metadata, it's not a record, because the content at issue here, it's not just something about a communication, like I was in this place when I sent this email.
It is the location.
It is the location. Like the reason you're transmitting this to Google is for it to store where you were in order to create your timeline. So this is content, and the government actually doesn't dispute that in its
Talk to me about Virginia and other similar statutory laws in this area.
So Virginia has a statute, the Virginia Computer Crimes Act, that defines data on a computer network to be a form of property. It creates criminal liability for trespasses. It also creates civil liability for malicious trespasses. And so, we view the question of whether a property interest exists to be one of federal law, like the court held in the Tyler versus Hennepin case. The court should consider a common law rule, not state by state. But I think state law is a pertinent input into that ultimate federal question. And the fact that Virginia and many other states have explicitly recognized data as a type of property and have created statutory torts for trespass on that data.
The case name is right over here, and some information about it.
Question if we just resolve the case in your favor on one of the particularity grounds, right?
Well, I think the government would say that if it's not a search at all, it didn't need a warrant in the first place.
If we assumed it were a search without deciding, we could just decide it on particularity grounds. And you've talked quite a lot about step 1 particularity problems you see. Can you talk about the particularity problems you see at step 2 or step 3?
Sure. So I think the problem at step 2 and step 3 is that the government conducted these follow-up searches, right? So they got an extra hour's worth of information about 9 people, and then they de-identified the people. But the warrant did not identify those people with particularity. It didn't even identify a means for the government to find those people. All it said was the police are going to figure out the really suspicious people, and they're going to do those extra searches. So the government says that the original warrant was a sufficient basis to de-anonymize and get the 2 hours from everybody in the geofence. So that's wrong for a couple of reasons. One is it's just clearly not probable cause to get 2 hours of information, including data outside the geofence, merely because someone was sitting in church within an hour of the crime. And second, even though geofence warrant itself doesn't authorize that, it doesn't say the police can go ahead and collect data from everybody. All it says is that once the police winnows down the 19 or however many there are to some smaller number, then it can collect additional data. But that's not particularized because it doesn't say how to identify those people.
Would that be a narrow basis on which to resolve this case?
That would be a very narrow basis. I would caution the court that if the court resolves the case on that basis, then in future cases, the government can cure the problem here by just obtaining another warrant before step 2, which may be the answer. But that would be a particularly narrow way of resolving the case. Obviously, we have concerns with step 1 as well, and so we believe that's unconstitutional.
Thank you.
Justice Kavanaugh?
Assuming it's a search for purposes of this question, and that I don't buy your general warrant argument, how can you overcome Zurcher for purposes of your argument that it's not sufficiently particularized, et cetera?
Okay, so I view Zurcher as answering a very different question from this case. So Zurcher holds that the Fourth Amendment permits a search of a premises of someone who is not implicated in the crime at all, as long as there's probable cause to believe that there's evidence on those premises that will be pertinent to the criminal investigation.
And here we have that.
We do, but what we understand to have happened here is more like a search of 19 separate safety deposit boxes rather than one single place, the Stanford University office, like in Zurcher. So I guess here would be a relevant physical.
Why do you characterize it that way? It doesn't seem that way to me. It's search of one place.
Well, the argument the government would make is that Google, like the expansive entirety of Google servers, are a single place. I think that's a pretty dangerous holding, because if the court were to reach that...
We're talking about a warrant that's sufficiently particular here. So it is a search for purposes of this question, but it really just boils down to, I think, is the warrant sufficiently particular?
Right. So if the court considers Google...
So we have probable cause. You admitted that correctly. And it's just then, is it sufficiently particular? And it seems like Detective Hilton here, really went through a lot of the steps that should be applauded.
Poor Detective Hilton.
Narrowing this down, going through multiple steps.
Sorry, y'all.
Trying to figure out why this was bad police work to get a warrant. A lot of Fourth Amendment cases, we say, get a warrant. Well, they got a warrant. And then you're saying, it's not sufficient.
It's not sufficient.
Multiple steps. How many names were ultimately given to the detective?
Well, it was 3 devices, Your Honor.
3 names. So in the end, 3 names. You were talking about millions and millions, but it was 3 names in the end.
So first of all, I'm not casting any aspersions whatsoever on Detective Hilton. There's no sign of any kind of malice whatsoever. That's not our argument today. Okay. We do think that the warrant was defective, and if I could just make a couple points about your questioning. So first of all, I understand a warrant was obtained here, but the court should be realistic about how much protection the warrant requirement really provides in a case like this. Sorry, Your Honor.
Well, that's what the Fourth
Turn your
Amendment
location
says.
off.
Keep
That's all
going.
I'm going to say.
So the warrant
The
requirement.
Fourth Amendment's a floor, not a ceiling of protection, and the warrant requirement, we have to stick with the words of the Fourth Amendment and the history of it.
All I was going to say is that the government obtained a warrant merely because someone was holding a cell phone near the scene of a crime. And if that's enough to obtain a warrant, it's going to be obtainable in a wide number of cases. That's not just a factual quirk about this case. That's many cases in which this type of warrant is obtained. But I'm happy to stick with the warrant.
Geographically and temporally limited, though, the warrant.
Yes, but the Fourth Amendment.
In a way that the magistrate, a third party, not the executive, not the law enforcement, will neutrally review and oversee. And lots of times judges will force the warrant to be narrowed, right?
Your Honor, the Fourth Amendment requires particularity as to the place to be searched. In this case, the geofence was not the place to be searched. The place to be searched was these Google accounts.
So suppose we have a murder and we know, all the police know is that the murder was at a restaurant, a particular restaurant. And so the search is for, the request is for everyone who dined at that restaurant in a 2-hour period and for the names of those people. Thoughts?
So if the court doesn't buy the argument about a general warrant,
correct,
okay, then it is possible that you might say that there's probable cause that people who were actually witnesses to the crime, they were at the restaurant when the crime was committed. You might say there's probable cause to believe that there's relevant evidence in all of those people's accounts. Here, we don't have that. So first of all, I view this as a search of—
Well, let me alter the hypothetical, or maybe all you know is the murderer was in the restaurant, and the search warrant or subpoena, the search warrant is to the restaurant for the list of people, to the restaurant for the list of people who were in there in a 2-hour period.
That is perfectly fine. A subpoena or even a search warrant could be issued—
And that's different from this, how?
That's right, because we view that as not a search of one entity's property, like one single piece of paper containing a list. We view this more as a search of 19 different people's private papers. Ultimately, the question is the Fourth Amendment.
You only got 3 names, but—
Oh my God, quit dicking around.
You agree with Zurcher, though? There's nothing from Zurcher you're asking, including the footnote, there's nothing from Zurcher you're asking us to depart from?
Correct.
Okay. This is just more practicalities, but the local government amicus brief and the 31 states amicus brief, which has a huge spectrum of attorneys general on that amicus brief, which I think warrants note, talk about the practical consequences of not being able to solve it.
No attorney general would ever want to push to make warrant requirements easier.
Just want you to respond to that.
Sure. So first of all, we're not suggesting that all law enforcement techniques that allow the police to determine everyone within a particular area are inherently unconstitutional. We think this particular technique of serving geofence warrants on Google and requiring searches of a sensor vault, we do think there's a constitutional violation there. But there's many other law enforcement techniques that deploy modern technology that would not present the same types of issues. And the other point is that—
Such as?
So we haven't taken a position on the constitutionality of tower dumps. That presents a very different set of issues because that cannot be conceptualized as the search of lots of virtual storage lockers. There are other Fourth Amendment arguments on the table there.
No,
but I don't
my
think
life's
anything the
been
court says in
weird
this
this
case
morning,
would impugn the
Morris.
constitutionality
It's like
of tower dumps.
I
Similarly, I don't
normally
think
have
anything
more
the court says
people
in this
and
case would impugn the constitutionality
I
of
shouldn't
things like
be
taking
flagged.
security videos, CCTV, and using those to identify suspects. So there are a lot of other law enforcement techniques that are available to solve crimes in which you know where the crime happened, but you don't know who it is. And we're not challenging those. We're just challenging this one unique particular type of method. And the other thing is, Professor Kerr's brief points out that there's actually quite a lot of geofence warrants that have been issued. Like the district court says there was 9,000 geofence requests issued to Google in 2019. And there's actually a fairly small number of reported cases involving motions to suppress. So it seems empirically that most geofence warrants just ensnare innocent people because I guess maybe criminals turn off their phones when they go commit bank robberies most of the time. And so, the law enforcement benefits of this particular technique, I think it's easy to overstate, even though obviously in this case—
Well, the local government brief disagrees with you on that, but
there's a lot of amici—
And they have specific cases, but I'll leave it there.
I mean,
Thank you.
I think our side has some philosophical diversity from the amici as well. So I think both sides have a lot of people with different views on this.
Thank you.
Justice Barrett?
Mr. Unikowski, would there have been a Fourth Amendment problem if the police had purchased this data from Google?
I don't think the police
love
could
that
have
question.
theoretically done that.
Why?
Because Google's policy is that it doesn't sell this data. It has a pretty strict privacy policy where it doesn't give the data away unless...
But it could. I mean, I'm just looking at the policy, and it says that Google may share non-personally identifiable information publicly and with our partners, advertisers, publishers, rights holders, specific partners to collect information from your browser or device for advertising purposes?
Right, no, so Google shares aggregated information like, how many people searched for the word YouTube last year and things like that.
But doesn't it share location information too? I mean, I feel like I get ads when I'm in particular places. I mean, I need to check my location services settings, plainly. Not that I'm going to commit crimes, but it seems to me
I
like
suggest
Google,
you have
Not
IT
today.
do it.
it does seem to me like Google does give your information away.
I don't think it does. I think there are other
Okay, well,
less
maybe it
scrupulous
doesn't
apps.
as a practical matter, but that policy, as I read it, does permit Google to do it.
I don't think it does. There's
That's not how
declarations
this
in the record
works.
that says that Google doesn't do it, and the
Barrett
privacy
or him?
policy says that it's not going to share individual
Barrett.
data with advertisers. I
Yeah.
think what you read is not a reference to location history.
It
I'm not
started
sure
out as a good
I don't think it is, Your Honor.
question, but
There's a declaration in the
it's
record, and
devolved.
there's live testimony, and there's a statement in the privacy policy that Google
She really needs to
does
learn
not
about
share individual
cookies and
data
programmatic
with advertisers.
advertising.
It just doesn't do that. Like, an advertiser cannot go to Google and say,
Don't
Okay,
hate
what
on
if it
me,
did?
law.
What if it violated its own privacy policy and allowed the police to purchase it? Isn't that a problem between, like, the person who has the Google account and Google? Would that be a Fourth Amendment problem?
It might not be a Fourth Amendment problem because there's like the private search doctrine. Even if someone unscrupulously but privately takes someone's data and illegally gives it to the government, you might call that a private search.
But
of the
doesn't
government's-
Google have, I mean, I guess what I'm getting at is, doesn't Google have some right? I mean, Google can dip in and dip out, at least under the policy as it existed at the time this search, or this possible arguable search occurred.
We view this as just like FedEx. So if you look at the FedEx privacy policy, FedEx says it reserves the right to inspect packages when it needs to do that. But I don't think that means that the government doesn't need a search warrant to inspect packages. In the same way that if you stay at a hotel, the hotel reserves the right to have a housekeeping service come into your room, and maybe the housekeeper will see your personal possessions, but that in and of itself is not consent to have the government do that. So likewise, yes, Google does reserve the right to analyze your data. Like if you went to a lot of ski hills, you might see a ski ad on YouTube, but I don't think that in and of itself meant you've waived Fourth Amendment protection with respect to the government seizing it without a warrant. I mean, if Google sold it, I don't think Google's even capable of that. If Google just voluntarily handed the data to the government, that might be a little bit more like the Jacobson case, but I don't think that's what we have here.
Thanks.
Justice Jackson?
So I guess I see you as making maximalist arguments about this in ways that I'm trying to understand if they're necessary to get to the point where you want to go. I mean, I thought the key issue was what makes a warrant for a search of this nature sufficiently particularized. That's one way to put it. And
I'm going to get some aspirin real quick. I'll be right back, Law.
We've got Google responding in steps. We have this warrant request. The officer, according to your brief, identifies a geographic area based on where the crime took place and the time. We have a bank robbery at X time. So what I'd like, says the law enforcement officer, is the location history data for 30 minutes before to 30 minutes after a 150-meter radius around the bank. Is that right? Is that how it starts? Okay.
Yes.
And as Justice Kavanaugh points out, at the end of the day, they end up with 3 names. But we have a lot of steps in between under Google's iterative process for giving the officer this information. So I guess what I don't understand is why you aren't arguing something about needing more probable cause as each one of these steps goes along. Yes.
I do think that is one of the arguments we're advancing today, that the government did not obtain a fresh warrant before it conducted the Step 2 search, and the initial warrant did not authorize all of the information to be obtained, from all of the 2 hours of information to be obtained from everyone within the geofence.
Right.
Yes.
Okay, so fine. But why isn't there probable cause? You seem to be fighting the premise that at the beginning, when the search is drawn, when the fence is drawn, 150 meters around the bank, 30 minutes before and 30 minutes after, and 19 accounts are identified, setting aside your general warrant point. Mm-hmm. You seem to be suggesting, or you're arguing, that there isn't probable cause to do anything more at that point. That something about the 19, they have to know something about a particular account. I don't understand that. Why isn't it enough to begin with to just ask as the magistrate, is your fence reasonable? Is the 30 minutes before and 30 minutes after, is a 150-mile radius? Like, why isn't the step one probable cause inquiry just, do we have a reasonable scope to begin with? I would think that we would just ask that, and that the answer in this case would be yes.
Well, except for that very last step, I don't disagree. I think the answer in this case would be no.
So what's wrong with 100? Is that too wide? Is that too big? Why is that too big under these circumstances?
Well, the problem is that we view what happened at step one, even before the de-anonymization happened, we view that as a search of people's private papers.
No, I understand.
And so if
and
that's...
You said in response to Justice Kavanaugh, it's not the whole location. Justice Kavanaugh says this is Zurcher, which I think has some force to it, that we have a location and there are maybe 18 people in this 19-person search who are going to be innocent, who didn't know anything about this, but just happened to be there in that time. But Zurcher seems to say that's fine, as long as you have probable cause to believe that there is a crime that's being committed in this location at this point. You say, no, it's each person's individual count. If we disagree with that,
okay,
all right, and we think this is Zurcher, then why is 150 meters or 30 minutes before or 30 minutes after unreasonable at step one?
Okay. If you think it's just like Zurcher, I still think it's unreasonable at step one, because I think the geofence warrant covers people who are just sitting in the church the whole time. And I think that geofence warrant that encompasses not just the bank, but also a church and a church parking lot 30 minutes before and 30 minutes after.
But we can't eliminate those. We don't know anything about those people. This is a reverse warrant, says Professor Kerr. You're allowed to have the radius encompass people who aren't necessarily the bank robber if you're trying to find the bank robber and there's probable cause to believe he was there 30 minutes before or 30 minutes after. Well, you don't eventually get those people's names. That's the point I'll get to. But for step one, I don't understand why there's a problem.
I guess that's the question, whether it's okay under the Fourth Amendment to say, well, we don't know which of those people it is, so we're just going to search all of them to try to find the suspect. Because that's essentially what happened here.
Okay, so isn't the real problem, if you're looking at it as I am, that the point that you made with Justice Gorsuch, that we don't understand how the police went from the 9 to the 19. That the next step in opening it up and looking for more information, there has to be some rational basis or probable cause to believe that these particular accounts we need to have more information for. And that's not in this record, right?
That is certainly true, Your Honor. The warrant just told the police basically find the people that seem most suspicious to you. And the police just initially selected all 19. Google pushed back. The police selected 9. But the warrant itself doesn't provide any criteria. And
if it did, would it be more particularized? And isn't that what we should be saying in this opinion, for example?
Well, that would be a different way to achieve a Fourth Amendment, to rule that the Fourth Amendment was violated. That would be a very narrow resolution of this case. But yes, I do think that alone is a sufficient basis to invalidate this warrant, even if the court disagrees with our broader arguments.
Thank you.
Thank you, counsel. Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the court. As I think Justice Jackson was just getting at, petitioner here is asking for an unprecedented transformation of the Fourth Amendment into an impregnable fortress around records of his public movements that he affirmatively consented to allow Google to create, maintain, and use. In doing so, he would make that fortress so impregnable that not even a judge's warrant for even a moment of the public location of someone who, again, affirmatively opted to allow Google to have those records and to access them would be available to law enforcement. That's a debilitating and counterintuitive reading of the Fourth Amendment that would impede the investigation of kidnappings, robberies, shootings, and other crimes, and would implicate any number of practices that I think opposing counsel kind of just waved his hands about, like tower dumps. Frankly, Mr. Chief Justice, I don't know how he concedes exigent circumstances, because under this court's recent decision just this term in case against Montana, we need reasonable cause to
you're
believe
killing me in these comments.
that there's a necessary search, and under
Melodramatic
his view,
much?
this would be a search of everyone who has location history stored with Google, and I think he would have to say that we don't have reasonable cause as to each one of those people. And the way he is trying to achieve that counterintuitive result, I think, rests on two fundamental misconceptions that have been emphasized this morning. One is that this is like uploading your own content to a storage locker. Even Google doesn't treat it that way. If you see it, if you look at Joint Appendix 55, you'll see that Google separates out user-created content from other kinds of content.
Yes,
The
because
second
regular
main
people often
misconception
go to
here,
the
if I
appendix.
might just continue for 1 second, is that this would implicate all sorts of other types of data in which the court has found more of a reasonable expectation of privacy, like email. Location history is different. I'm sorry, Justice Thomas.
Mr. Fagan, would you address Justice Alito's point as to this being an advisory
Attorney Dye, Alito has been on
Frankly,
one this
Your Honor,
morning, like
we
very pissy.
attempted to warn the court about that in our brief in opposition. If the court wishes to dismiss the case as improvidently granted, we'd be fine with that. I do think there's really no chance the opinion here would make the officer's actions here unreasonable. Petitioners suggesting now some kind of new kind of warrant requirement exception to the good faith exception. I don't really understand how that would work or what the contours of it would be, and I don't, what does it mean to have a new kind of warrant? At bottom, we just don't think there's anything that's going to happen here other than an affirmance. So you would essentially have something that looks like an advisory opinion. I mean, I suppose the court could say that the theoretical chance that something might happen is enough to keep this case alive, but I don't think that makes a great deal of sense.
Additionally,
It's hot nonsense.
Google's policy has changed, and would you compare that policy to this and the effect of that change?
Do you mean the pushing out of location
Yes.
history so it's now stored on the phones?
Exactly.
Well, I don't know that it would make a Fourth Amendment difference if Google were still able to comply with these warrants, but Google has represented to us that as of 2023 and that change that it made, it is no longer able to comply with the warrants, and that makes the difference. I'm sorry, Your Honor. But otherwise, if this were information that were exposed to Google, Google, I think it's an important feature of the warrant here that Google is actually the one doing the filtering on Google's accounts. As to any account except for the 19 that were additionally returned, and of course they were all anonymized.
Nobody cares.
And they were truly anonymized. Their expert, if you look at page 288 of the Court of Appeals Joint Appendix, admits he wasn't able to specifically identify even the 3 people he was talking about. But as to everyone else, other than the 19, they might as well not have existed from the government's perspective. And even Google didn't really learn very much about them other than that they were not within this 150-meter radius circle.
They were still there, and the government still looked at them, so it's still a problem.
An invasion of their reasonable privacy expectations. I think clearly not under this court's decision in Knotts. That's a public place. These were public movements.
Counsel, if I could interrupt.
Sorry.
One of the central concerns that's been voiced, of course, is what's to prevent the government from using this to find out the identities of everybody at a particular church, a particular political organization. What are the restraints that would prevent that from becoming a problem?
Well, number one, Your Honor, would be the Stored Communications Act, and I respectfully disagree with Petitioner's counsel. I mean, we have a somewhat different reading of the Stored Communications Act and exactly what it would require under these circumstances.
But it
And
only
I know
means
it's a
one
statutory
thing.
protection, but I disagree with counsel that it sets some kind of Fourth Amendment floor. The court basically rejected that position in City of Ontario against Kwan, which also involved the Stored Communications Act.
Well, put the statute aside, just in terms of the Constitution.
Putting the statute to the side, I mean, first of all, I don't think that there's any kind of categorical protection around something like a church. I mean, unfortunately, as you saw with Dylan Roof, we can have a shooting at a church. If he'd gotten away, I would have thought this would be a law enforcement technique.
So you don't think there's any constitutional protection from such organizations to be subject to focused surveillance that would cover everybody in the particular location?
Well,
I'm feeling it, Roberts.
Avenue that the court has potentially held open, number one, is the amount of time for which the government could look. I don't know that the government could see everyone who came into a church at any time.
Well,
but
if the services start at noon, they can go from noon to 1, however long.
He's grumpy
so
too.
let me make a few points on that, Your Honor. First of all, someone doesn't want it known that they're going to a particular place, like
Yeah,
an abortion
Alito's been in a
clinic, for
mood.
example.
Roberts has
They
been a
don't
little
have
bit of a
to
mood.
Enable location history
We'll put
or keep it
Catherine
on
too.
while they're visiting that location. I mean, if there were a surveillance camera at a bodega across the street from the church, that could also see everybody who came in, and I don't think there'd be a claim to Fourth Amendment protection from government review of that. The second thing that I think I would say is that this has been the degree to which someone can really be located in a particular location, I think is somewhat overstated in this case. If you want to look at the sealed volume of the Joint Appendix Volume 3, you'll see that usually there's a fairly wide confidence interval of close to, like 30, 40 meters for everyone. So, and that's only,
I think so, Attorney
that only
Dye.
describes a circle with a 68% probability of containing them. So it's
Well, but
difficult
I
to
don't
know
mean
exactly where they are.
I mean, we can't rely entirely on good faith, but the point is not that they're looking for a particular individual, but they want to have a catalog of the people who go to a particular location. And it seems to
He's
me that
asking,
that's a
can the
realistic
government put you on a list?
Well, Your Honor, first of all, I mean,
I thought the good faith exception was rarely used because it's the weakest.
And the second,
It's come up like 6 times
okay, and the second
between
thing I'd say
with
is,
the last
I
attorney
would
and this
focus on
one.
this particular case and in every case in which this has come up. The government has gotten a warrant because Google, it's just easier to get Google to comply if we do get a warrant. And if you want to put the warrant aside, Your Honor, I do think that what really matters here is that people have
The warrant's the whole
affirmatively
reason we're
opted in.
here.
Only
We're not putting it to the
1/3 of
side.
active Google account holders do
So
that.
to prevent surveillance of sensitive locations, you have to rely on the fact that people are going to turn off something that many, if not most people, find is an important service.
Well, Your Honor, I do think if you wish
Amen,
to
Roberts.
conceal that you are at a particular location and you are effectively shouting and broadcasting your location to Google, and that Google is creating, maintaining,
read it out of the
using
fourth.
for
Thank
any
you,
number
people.
of its own purposes, those records. I mean, Google could send you an ad saying, hey, I
Fagan,
see you go to...
Mr. Fagan, I'm sorry to interrupt, but I got to think the answer to the Chief Justice's question is yes. This isn't a search. We don't think it's a Fourth Amendment search at all. You don't need a warrant. And yes, if we want to determine everybody who is at a church or a political rally or the abortion clinic or anything else like that, we can do that, as long as we can get Google to comply.
That's my man,
and we
Gorsuch.
might have a few tools besides warrants to get social media companies
So on the
to comply
last
with
pass,
governmental
Gorsuch
requests.
was kind of like
So I
not
do think that
feeling,
effectively is our answer,
or
Justice
was like
Gorsuch. I'm
trying
not
to
walking
settle
away
it
from
with
it.
the
I'm
other
simply-
attorney.
I'm
It was
simply
good.
noting two
I
very important
I
features.
understand that, but that has to be your
why.
answer. And then there's a little tension in your argument as well. You're saying the sky will fall if you can't do this. That you started off with that. That was the very first point you made. How important this is.
My favorite spicy judge.
And then in the next breath, you said that Google can no longer provide this information because it is reconstructed how it operates. Can both things be true?
Yes, Your Honor. and here's why. I think a lot of the arguments that are being made here today and are made in the briefs, if accepted, and I think, again, this is something Justice Jackson was getting at, would have a debilitating effect on a number of other law enforcement techniques.
Like looking at email.
So email, Your Honor, we get a warrant for email.
But again, you don't think you need one because they broadcast it, as you say, to Google. It's subject to very similar terms of service.
That's not correct, Your Honor. We view email differently, and there are several reasons.
How about Google Documents? How about photos?
We view all of those differently, and there are
just location data that's different?
Yes.
Okay.
And this court has made clear that it's different. So in Knotts, the court makes clear that...
Could you just footnote that answer?
Sotomayor.
Are they different because you treat them differently, or are they different because something in your theory doesn't apply to them?
Your Honor, I was just getting to that. So we think they're different because the court has always treated like the contents of one's personal thoughts as recorded differently from one's exposed public location, which is all that's at issue here. At least
How about a calendar?
So your calendar, I also think, would be different from your location history, because a record, your own personal,
I think your location history is by far more personal.
And there are several reasons for that. I think the court has made clear in Knotts that exposing your public location for 2 hours, you don't have a privacy expectation in that. And that contrasts sharply with cases like Ex parte Jackson about physical letters, or even a case like Katz, which is about telephonic communications. Second, I think that's consistent with the original understanding of the Fourth Amendment. Justice Thomas gets into this a little bit in footnote 8 at page 351 of his opinion.
I love the cops reference.
About how the
you won't
original
reference that
focus
enough.
of the Fourth Amendment was protecting personal confidences.
He was a dissent there, though.
On this particular point, Your Honor, I don't think there was.
Yeah, but Mr. Fagan, I do think
inconsistent
that
with what the
Carpenter
majority-
seems quite relevant to this. What you're now saying is
Kagan?
location
Go,
is
Kagan.
different from email and photos and calendar appointments and everything else that people give to Google. And the reason is that location is just
Me too,
different because
Bubbles.
people just think that everybody knows
Yeah, and
where
that's
they
my
are
thing is
all
that
the time.
location is
But I
no
would have thought
different
that
here
Carpenter
to
had
me.
something to say
It's
about
just
that.
as important as your
So,
calendar, and I would
one
say it's
point,
more
and then
personal.
I have 3 different reasons why this case is different from Carpenter, but well, let me just jump to the 3 reasons because that's what you're asking about. Number 1, we did exactly what Carpenter instructed us to do in this case. We got a warrant. Number 2, I do think Carpenter and Jones.
But you're saying you didn't need a warrant. So, I mean, I think the question is your theory, not what you did out of the goodness of your own heart.
Putting the warrant, which I think is the easy way to resolve this case, to one side. I think there are 2 key distinctions between this and Carpenter. 1, in Carpenter, you had essentially
Go big. It's not about where you are.
CSLI,
This is about what they can access on your data.
As the price of even having a cell phone, which the court had said in Riley was a device that basically nobody can live without.
This is a side note. This is probably one of the biggest data privacy cases they're taking this year.
Standard?
That's the one fixed point that the court has given us. But here we're a long ways away from that, because even 1/3 of only 1/3 of active Google account holders bother to enable location.
So where's the line if 80% enabled this? Would that make it a different case?
I think that would be much closer to Carpenter, because I think, if I'm recalling
this is
correctly
where we
from
draw the
Riley,
line?
it's something like 90% of people have cell phones. But I certainly think 1/3 of active Google account holders, which is a fairly small percentage of the world's population overall, shows that people don't need this. You can use Google Maps
Using
without
the world's
location history. You can use Google Maps even without a Google
U.S.
account.
population, which is a lot of
The
Google
second thing I would
account
say about
holders.
Carpenter is that although neither Carpenter nor some of the separate opinions in Jones, like Justice Alito's opinion that you joined, drew clear temporal lines, I do think both Jones and both the opinions in Jones and Carpenter focus on detecting the patterns of life. And long enough periods of location to show the patterns of life. I don't think 2 hours is enough to show the patterns of one's life. They might show that you went to a church once. It doesn't show that you're a regular churchgoer. It might show that you went to a doctor's office.
I guess one question would be, why is it, why would the only thing that you would have an interest in protecting is the patterns of one's life, as opposed to the things that you do in one's life that you particularly don't want people to know about, such as going to a political event, going to an abortion clinic, etc. It's like
I was thinking the porno places.
I can tell you a lot of things about the patterns of my life.
That one
what
too.
I really want
Honestly,
to keep
I'd probably
private
put it on
is
Facebook.
particular
I'm
things
pretty
that I
open.
might
But either
do,
way,
on very discrete occasions.
Well, 2 points, Your Honor. One is, I think the fundamental insight of Knott's is that if you walk out in public and you walk into some sensitive location, then
but I firmly believe that anybody should be able to go anywhere they want, even the corn stores, without the government knowing. I want to say that.
People to private residences through the use of a beeper and stopping outside the private residence. Maybe you don't want someone to know that you're having an affair, but if you have a beeper in your car under Knott's and they're following you for 2 hours, they will find that out.
Would your position be the same if you
Besides
had
doctors,
picked up
besides
Mr.
doctors.
Chatrie in his home?
You need to come back.
You know what? Do they track my location? If not, then I'm good with it. Let's go back.
The joint appendix from this court that shows that we couldn't locate which of the houses was his, even though he eventually did go to a house, because, as it turns out, because the confidence intervals were simply too
low. But your position would remain the same.
I don't know if they do Midwest, but find them if they do.
In his home at the time.
We're getting beepers, guys.
Well, Your Honor, I guess I would make a couple
and we're bringing
points.
back MySpace.
I think that we would argue that. I think the court could draw a distinction. And the reason
I think Law of the Wild's going to pay for it, right?
Remain the same is, number one, we had
He's
no
in
warrant.
Zoom court right
Number
now.
two,
He was like, I'm going to be in Zoom court, but I'll stay on. I'm just not listening. I was like, all right.
Validate the law enforcement technique ab initio.
We
it
love
just means that someone
I'll
was
send him a
standing
note.
to suppress the information
5,000
about
beepers,
the
please.
home.
We need 5,000 beepers, and we need you to reboot
I think
MySpace.
This is distinct from other home circumstances precisely because of the opt-in and the fact that the person is advertising the fact that they are at home, sharing that with Google, and Google could say, you know, Google could say, I see you go to church every Sunday. Maybe you'd be interested in this particular religious item. Google could say, I see you're often in the house on Saturday mornings. Maybe you'd be interested in this particular thing that could be delivered to your house on Saturday mornings. And so they are opting to share that information to get a purely voluntary service, and they're doing so, if you want to look at the terms of service, which we agree aren't controlling, subject to the full knowledge that Google, of what Google is doing with it, and the ability of Google to respond in good faith to law enforcement or to make any number of other choices, like sharing with service providers, for Google, that will expose that information to public view.
You're really saying, you're leaning pretty heavily on the correct proposition that what you do in public view is not generally, you don't have a reasonable expectation of privacy in. But now you're telling Justice Kagan, really, that if you go into a private home, it wouldn't be a search? If you trace location services? I understand in this case, and is that true that in this case, you're saying you didn't pick him up in any home?
Well, Your Honor, he eventually stopped at the end of his
public
journey
view,
away from
yeah,
the bank
sure. You
at
probably
a
don't
group
have a
of
right
homes,
to
but there's
privacy
testimony
there,
is
but
that
it doesn't
paid
mean the
$1.1.
government can just pull your shit.
We couldn't tell which home he was even in.
I hate that argument.
Okay, but you really are saying that you could track someone going inside a home. Justice Sotomayor asked Mr. Unikowski about movements inside a home, movements to the bathroom, movements to the bedroom, all of that, if the confidence interval is narrow enough.
Your Honor, I think what I'm saying is two things.
That's a yes or
One,
no.
I do think we could have done that here because of the warrant.
Who wants to Google our
I think the question is that a search under your...
Is it a search? I don't I think probably, Your Honor, like, I acknowledge that's going to be a much harder case for us.
But no,
I think
Do
if we were
they
to
even
argue that, I
practice
think
their
I'd like to
arguments,
reserve the
the
possibility that
Solicitor
we could
General's
argue that
office?
it's
I'm
not a search
concerned.
principally because
Doubt
of
it,
the
doubt
opting and the
it.
broadcasting. But look, I fully accept that that would be a very, very difficult argument to sustain. Nothing in our argument
Is she saying then
on it. And
if they
I'm not,
cross
like,
threshold into the
saying
house,
that's
there's no
critical
more
to our
castle
argument,
doctrine?
and if the court thinks that that is a
Well,
bridge
yeah, I
too
mean, that's what
far,
she's asking him
I'm
because
fine with
he's like,
that.
well, you know, if you go in that,
Except for
like,
it's
that doesn't
totally
make any
inconsistent with your
sense.
theory, but other than that.
Other than that, Justice Gorsuch.
On the particularity side, Mr. Fagan,
Gorsuch.
let's say you go to a hotel, and the warrant
You know,
is,
it's like I hate him as a
search all the rooms
person,
in the
but
hotel
like
for
when
the
he
gun
gets
on the bedside,
spicy, it's
or,
my favorite thing.
the
I
storage
also like his
facility,
voice. I
search
want him
all
to
the
read
storage
books to me at
units,
night.
For
It's good entertainment,
particular
but
contraband.
Yeah, like
or
I can
to
hate him
bank,
as a
go search all the
person,
safe
but I
deposit
appreciate the
boxes,
attitude, you know?
for the pearl necklace
yes,
that's been
I'm with you on that one.
What's the difference between those cases and this case, assuming that I have a term of service with the hotel, with the storage facility, with the bank, that says you can access these places from time to time for purposes that we agree upon, and of course, you can do something with the government if the law allows it.
So, Your Honor, I think this is this goes to a somewhat under-theorized portion of the Fourth Amendment, which is the definition of a place. I think we often have an intuitive sense of what's a place. In particular, with an apartment building, I think...
You would agree those warrants would all be impermissible?
I don't know necessarily about a storage locker one. That would probably be impermissible. Certainly, we couldn't search every apartment in a building, both because homes are first among equals and because...
Hotel rooms, bank safe deposit boxes, storage facilities, the warrants I've just described, go search for the contraband, the gun, the pearl necklace. Okay or not okay? Are those sufficiently
Not the
particularized?
pearl necklace.
Well, let me take them each in turn, because I think the analysis might be slightly different under each of those things, Your Honor. First of all, for the apartment homes, no, and I think that's...
Still haven't asked about apartments, asked about hotels, but
I'm
okay.
sorry, a hotel is the same because the court's treated it as a home.
Okay.
And houses are specifically listed in the Fourth
All right.
Amendment, and they're
All
first
right.
among equals.
How about the other two?
Okay, I think storage locker, I think probably we could not do that, and I think we probably couldn't do a storage room, although it would depend how it's organized.
Like
But
every storage facility in America, you know, with one of those awful rolling gates and a padlock at the bottom.
So let me explain why that's different from this case, if I could.
Yeah, I'm just
He's
asking
gonna
if you
get
think
mad.
that warrant would be sufficiently particularized, the one I described, yes or no?
I think it would be sufficiently particularized because it would describe what the government has.
He's a lawyer, and even
basis
worse,
to
he's a
search
Solicitor
The
General.
government could
But
ask
what I don't
the
think
storage
is-
facility
Oh my
and
gosh,
require
don't
them
talk
to
over
search
him.
every locker and 500 lockers for the contraband.
What I don't think is that it describes discrete
Be
Fourth
careful with
Amendment
Gorsuch.
place in which to search for
Like
the
I
thing.
said, the
So it's not
spiciness is
particularized,
unrivaled.
So I think
I'm
it's
really
more
just
about
looking-
place than particularization there, assuming there's probable cause to believe that the area writ large is going to contain the contraband. If I could explain a little further on this, Your Honor, I think what makes the difference in some of these hypotheticals versus what we have here.
Well, first, I just want an answer to my hypotheticals, and then we'll get to here, if that's all right.
Your Honor, my answer to the hotels is
said
no.
not today.
My answer to the other two is very likely not.
Okay.
Yeah, I would need to know a little more about it.
Okay, all right.
And now, let me
now-
explain why.
And now turning to this, do you agree that Google had to query every single user's account?
No.
Well, you said
I mean,
so on page 10 of your brief.
do you mean
page
query
41.
do you mean query is like a synonym for
I'm using
search
your
in the
word
Fourth
from
Amendment
page
sense?
41.
He has got to
Okay,
stop
yes,
talking over
I do agree
him.
Google had
Yeah.
to query in that sense. I'm sorry, I thought you meant
And there are about
query as a
500
synonym for
million
search.
users'
Need
accounts.
clarification before you
agree.
answer that so quickly.
I agree, and let me tell you why it's different. I think the reasons the hypotheticals, but I apologize for misunderstanding your use of query as a synonym for search. The reason this is different.
Are you fucking dumb?
Is I think it's a lot
Sorry,
about
like, it's just,
opacity
bro, come
and
on,
control. What I
context
mean by
clues,
opacity
baby.
is the separateness of the different spaces. And control is who has control over those spaces. Here is a case where I think, as the court recognized in Riley, can often happen. The physical analogies kind of break down to some degree. The court
He really
has
hates
been
himself, and I
clear
love this
in
for him.
Smith against Maryland.
Well, let's just stop there.
Yeah.
Let's assume that these accounts are kept in, you can call opacity or whatever you want, but are kept in the same kind of discrete manner as your email is.
Well, Your Honor, I don't think that's the case here. I think
Let's assume it is. Let's assume it is. Let's assume that the Google user account, we've got a lot of briefs on this.
So, Your Honor,
they're categorized
Oh my God,
similarly by user and walled off from other users, both the email and the location data. Let's assume they're similar.
You never interrupt a
Your Honor, if
judge.
this were a record that the user
Exactly.
created and uploaded, our answer to this case would be different. But in this case, this is a record that Google creates, Google software sends
Listen,
it, Google
people,
processes
now that you
it,
got
it
your
runs
degree,
its own
and you
algorithms
know,
to
I'm
actually
just
figure
messing
out
with
what
you, dude. I
information it's
appreciate the
storing.
clarification.
It is data that Google maintains and data that Google accesses for any
I agree,
number of
Bubbles.
reasons. If we were to have a physical analogy to storage lockers, and I'm not sure how useful these physical analogies are, it's like having a bunch of storage lockers where there's a glass wall in front of them instead of having an opaque door for each box. All the government is asking for here is to get in the room and look at the front of those storage lockers. I don't think that the limited amount that even Google sees at step one is going to be considered a search. And for, as I said earlier, from the government's perspective,
Just because you don't
all
think
of
it's a
those
search
other
doesn't
storage
mean it's not a
lockers, if you want to
search,
call them that,
sir.
and we're accepting that analogy for purposes of this answer, all of those other storage lockers might as well not exist. For all the government knows, there are only 19
Michael,
people
are you down
who
there
have their
starting
locations.
shit in
Mr.
my
Reagan,
chat?
this is
I'm
because
here
at
for it,
step
Pookie.
one,
Love
unlike
you.
the examples that we've been talking about,
Oh, there we go.
you don't
Let's
know
get some.
how many apartments there are. You don't know how many storage lockers there are. At step one, it's just like
Seems like
getting
he's been a
list.
little
There
disrespectful
are
to the
16
women.
apartments in this building.
Yeah, we're about
Right?
to hear it.
And that's why I'm appreciating a difference between the steps.
They
as
almost always are
the,
too, and I'm like, I
iterative
wouldn't do
process
that.
with Google goes forward.
Except
Step
for Justice
one
Barrett.
is we
They're usually
have a
kind
bank
of,
robbery.
Yeah.
Here's the bank. We would like to know how many cell phone accounts were in this radius during this period of time, right?
Yeah, that's a good
You
point,
don't have the
Bubbles.
names. You don't have anything more than that.
I
I'm
want y'all to
struggling
watch
understand
his
the step
attitude
one
change.
problem, other than to figure out how the government came up with 150 meters and 30 minutes before and after. So can you start maybe by answering that question? Where does that where do
Sure,
those
I
numbers come?
can't help your struggle with step one because I too don't see a problem with step one.
He
But
did
the,
not just say that.
150
He
meter
did.
radius and the
She's
half an hour before
obviously
and
an
half an hour
idiot.
after were based on wanting to exclude, there's some testimony in the record about this. They did want to include the church
I didn't think it
because
would
they
be
had
that
testimony
straight out the
about
gate,
a
but
suspicious
wow.
car that
That's
had
pretty
been
bad.
parked at the church. And they thought the robber, as it turns out,
Just wanted to be like, well, I
might
can't
have
help
come
your
from
case then.
So evidence was presented to the magistrate. The reason why we're making the circle this big to include these structures is because there could be some connection to this robbery.
I don't believe that that particular.
And I want
reason
everybody
for
to
including
notice
that
how
was
she is
presented
such
to
a
the
champion
magistrate.
that she didn't even
All right.
bother with
Explain to
his
you how they
shit.
got
She just kept
150
right on
meters,
rolling with her
and
questions,
half an hour
did not
before and half
care.
an hour after allows you some information about, for example, there was a reference, and the magistrate did learn this, to co-conspirators in the demand note, and you might want to see if someone dropped the robber off or someone picked up the robber afterwards. You want to know more about the movements around it. The advantage the magistrate has that I think is difficult for a reviewing court to replicate is knowledge of local conditions and realizing that 150, if I could just finish the sentence, Your Honor,
Sure.
150 meters in Midlothian, Virginia isn't likely to turn up the entire phone book.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
You've been asked quite a few questions that analogized what happened here to searches, old-fashioned searches.
Alito is the worst
physical
person on
places.
God's green earth.
So
I
searching
hope his pillow's
the room
always
of
warm.
everybody in a hotel. If that happened, I think there'd be an awful lot of angry hotel guests, all of those who had nothing whatsoever to do with the crime. Here,
You fucking think?
Mr. Unikowski says 500 million people were
I can't believe we're
injured.
still debating hotel
There was
room
a
privacy.
search for their
Jeez.
data, even though it was completely anonymized. How many of
I
those
can't
500
believe
million
that we're
people
just
have
debating
come forward to
basic
complain
privacy.
about
Like, I
anything
have
like
no
this?
problem
May be
if they
going
need to
on
get
every day.
access to somebody's
Well, I
cell
think that's
phone
right,
with like
John.
a
I think that points
specific
out that if they did
warrant
want to
and things like
complain,
that, but like,
that would be a
this just,
separate Fourth
this is
Amendment standing
crazy.
question, of
Like, you
course.
shouldn't just
And
have rampant
I don't think
access to
that
all this
petitioner
data.
here can represent their standing, but one reason they wouldn't complain is, first of all, I don't think this would violate the reasonable expectations of privacy, even if the government were doing it. Second of all, Google was doing it, and it's no different from any number of other things that Google does for its own
Well, they're private.
particular purposes.
Not the government.
Don't you think that makes a difference
Listen,
for Fourth
when
Amendment
I'm at
purposes?
Chippendales, I
Distinction
want it to be
between
private, y'all.
a
Leave
law
my shit
enforcement
alone. Leave me alone.
officer invading a physical space and a request to a company to conduct a search with which the company complies?
Well, not only do I think that, Your Honor, but I think the court has said that multiple times. If you look at cases like Oklahoma Press against
His voice
Walling
is awful.
or Lone Steer, it's very different when an officer comes into the premises and looks around versus something that functions, although this had the protections of
You
a
know what? That's
warrant,
right,
in many
Midwest.
ways it
I'm
functioned
proud of
like a
it.
subpoena in that it was the provider doing the filtering and the provider disclosing the records, which
Just call me the
limited
next
what
time,
the
all
government
right?
saw
Or text. I'll go with you.
considerably. The only
I'm
I'll bring the
for it.
change.
non-anonymized information
I'll bring
the
the
government
change.
got was for 3 individual
I honestly
users.
don't even know
It
where
didn't
it
know
is,
anything
but
about
like,
anyone
I'm
in the
just
censor
always
vault
messing
other
around
than
with
the
people. I would probably
19
go
that were
though if I
returned
was
for
ever in a
step
place
one,
where
and
it's
as to
at.
them, it didn't know their
I
identity.
live in the middle of nowhere though. The
So
only
I do think
Chippendales we
that's
have
critical.
is backyard
but the
MMA fights.
argument that he's trying to make
Oh.
about
And that's
step
arguable.
one, I think it's very important that it really does implicate tower dumps, for example, because it implicates any number of law enforcement techniques that might incidentally find data about someone else. Even a CSLI warrant, you might have a company that organizes its data by tower. And in order to find, let's call him Carpenter, in order to find
I don't think
Carpenter's
demographics
CSLI
would be
data,
enough, Michael.
the company has to
You've got to
search
get your
across
probable
all of its
cause put
towers during the
together.
time period and
If you've
figure
got the
out
probable
which ones
cause,
are
you can be able
Carpenter
to
and
get
which
that
ones
warrant.
aren't. It's going to learn everything about all its users.
Yeah, and that's kind of like specific to
in theory.
these.
I mean,
Like
I'm
they're
sure it's
kind
using
of
software to do
almost
this and
reverse.
having a
Like they
filtering
come
mechanism,
backwards,
just like
and that's a
Google
big thing
here.
that they're alleging
But it's going
here.
to learn everything about all
What
its
was the
users for
probable
that period of
cause,
time.
you know?
I don't know how he
Right.
distinguished that. For tower dumps, I don't know how he distinguished.
Tower dumps are not
Exception to the
before us.
warrants
Emails are
clause
not
is kind of
before
what
us.
they are
Calendars
trying to
are
talk
not
about right
before us.
now.
Photos are not before us. I mean, I
Yeah,
understand
but like,
that. If
and
we're
I
going
can
to,
feel that, but like,
write a treatise
there's really no
on
exception in
the
this
application
case. I
of the
don't
Fourth Amendment
think.
to the new digital world, we
If
might
you
not
think
have
a
to
homicide has
section
occurred, you
clauses,
could
but
use
Yeah.
none
that
of those
without
Like
having a
hot,
warrant.
the
issue
type of like
in the
hot
actual
pursuit
case
type,
or
you know, like trying to. Yeah, I get you.
is
I love
before
hot
us. We've heard
pursuits.
some proposals.
I think
Me
all
about,
pursuits
too.
should be hot.
I know, right?
which
Like I'm here for the hot pursuit.
could
That's
be
why I go to
decided
Chippendales.
that would, as I understand them,
Yeah, they had a warrant.
focus on whether
There was a murder
lack
in the
of
hotel.
probable
Okay,
cause
stop
or lack
confessing,
of
Michael.
Clarity at step 2 or
With a
step
candlestick.
3. What would be the precedential importance of a decision like that, which turns on the particular warrant that is at issue in this case?
Well, Your Honor, unless the court upholds the warrant, I do think the court needs to reach the search questions in some way, because the court would have to address whether the warrant was even necessary. And I think, as I've tried to make clear, the court, a lot
Warrants
of the
are per se
arguments that
necessary.
petitioner
That's
is
in the
making here,
Constitution.
while those other
Dumbass.
techniques are not directly at issue would have
I think this government
implications
just
on a
really
lot of those
hates
other
warrants.
techniques
Like they're
and
always
would
trying to get
create a
around
lot of
warrant
litigation
requirements. And
and
I
have a
love
potentially
warrants. My
debilitating
favorite thing to
effect on
follow
law
is when
enforcement.
cops fuck up
But
warrants.
they could even
Like,
affect such things as
Exactly.
visual camera
like just get a
surveillance.
warrant, baby.
But
It makes
as
the
to the
life so
specific
easy.
question you asked about the particularity at steps 2 and 3, I do
Which
think it
is
was
also
sufficiently
in the Constitution.
particularized because
They
you
didn't care
had
about the warrant for
geospatial and
Biden
temporal
until they said
coordinates
they
that
didn't
showed
need
that these
one because he
people
said,
might
come
be
on in, take a
either
look.
suspects or
Amen.
witnesses, and the government simply was able to obtain enough
I've always
information to figure
been a fan
out
of like get it and don't
which
need
of
it.
them
You know, if
might
they invite
have
you in,
information
cool,
or
we're
be
good. But
worth
like, have that warrant
identifying.
just in
And
case.
I think the court's been clear
It's not
that
that
those
hard
are
if you have probable
permissible
cause to
law
get a warrant.
enforcement
It's really quite
interests.
easy.
The
At
court
least
might
in all
say
the
that-
time I've dealt with warrants
I'm
and
sorry.
judges,
Let me
they're
just
not
add,
exactly
I
like,
don't want to take up
I'm not
too
doing
much
this.
time. Let me just ask one final
Right.
question of all of the
My suggestion's always to law enforcement is if you get in the room and get whatever you're looking
which do you
for,
think
but you
would
feel
be
like
the
there's
most
more,
disruptive
pause the search, go get
what
another
everybody
search
has
warrant.
understood to
Go
be
clean
the
that language up.
limitations of the Fourth
Exactly.
Amendment up
Like
to
it's
this
so
point.
easy.
His
And like a lot
argument
of
is this
time
is a
with the
general
warrants,
warrant,
which
an
great if
argument
it's like
that
in
he
plain
had a
view,
property
you don't
interest
have to worry
Mhm.
about it
in,
anyway. But yeah.
in this data that was collected by Google. His request that we treat this search by a company as if law enforcement officers were themselves searching through.
Oh, welcome, Crooked Arrow.
Records.
We're just nerding out with SCOTUS.
Which is the worst?
Is all of
It
the
is
above
deep,
an option, Justice Alito? I do think the idea that you have a privacy right or a property right and even a moment's worth of location history could be debilitating to all sorts of types of visual surveillance. The agent theory could debilitate subpoenas. The property theory, I don't even know where the Fourth Amendment goes after that. And I do think a lot of these theories are, and the general warrant theory that Your Honor mentioned, I think would call into question how we do a lot of computer warrants. We often name the servers as the place to be searched. And I don't frankly know, and I don't think courts are well equipped to find out exactly how data is organized within a particular company, and I don't know whether we have to take discovery on that in every case where we seek a warrant and actually really go down to the nuts and bolts or the virtual nuts and bolts of how a company does this.
All right, thank you.
Justice Sotomayor?
A few questions. Number one, the Stored Communications Act, a violation, Mr. Unikowski said, may be a violation, there may be criminal penalties for it, but it doesn't give a suppression remedy, correct?
That's right.
All right. Number two.
That's a tough one.
You're saying everything would be horrible, but Carpenter has already said you need a warrant, correct, for data?
Right.
And we got a warrant here, yes.
All right. But you're saying I didn't need a warrant because it was a short period of time, assuming I disagree with that.
Well, Your Honor,
just
You always need a warrant. Objection. You always need a warrant.
There are 3 steps to this process.
Except for exigent
Were the
circumstances.
3 steps
Right.
approved
Like if there was a
by
homicide or a
the
murder in
warrant?
the
I
hotel.
read the warrant, but now I've forgotten. Were the 3 steps approved?
yeah, the 3 steps were all laid out within the warrant itself.
But the one who made the choice at step 2 and step 3 was Google, not a magistrate, correct?
Well, Your Honor, the warrant required the government to make reasonable efforts to minimize between steps 1 and 2 and
Well,
steps 2 and
usually,
3.
isn't it, I thought that if for the foreign checking system that we have, that magistrate judge says you have to minimize as you're doing it, but come back to us if you want a greater scope, correct? And here you went
Oh,
from 30 minutes to 2 hours, and you didn't get a magistrate judge.
That was expressly authorized within the warrant. The warrant's
ooh,
parameters
he
said
snapped
that
at
step
her.
2
No,
would
he's been
be an hour
snapping at all
before
the
and an hour
ladies.
after
Like,
the
I
robbery.
swear to God.
Okay, I thought it was 2 hours. Maybe I misunderstood.
That's a total of 2 hours, Your
I
Honor.
see.
1 hour
All right, I
before, 1 hour
misunderstood
after.
that.
The original was an hour, half an
He
hour
needs
before,
to
half
There
an
calm
hour.
are,
his
I
tone.
understood, many jurisdictions in which the government is going
Don't
back
be
at
talking
step
to
2 and
women on the
step 3,
court like
correct?
that, or I'll kick
You know
your
what's
It's
so
not
ass.
much of
sad? All the
a
women know how to
burden.
deal with
So
it
that
because they
means
Your
probably had
Honor,
it every
and you
day.
can
No,
explain
and
your
that's what I love
reasons
is
for
that like
why
Sotomayor
you're
or Jackson,
narrowing the
anytime they get
warrant
like that, they
and
just
why you
keep
need it at
pressing.
step
Like, and
2.
I'm cool. I love
You
that
could do that.
response.
we could
But
do
for
that,
me,
and with
it
more
just makes
recent
me
warrants, the
mad. Like,
government
I'm
has
just
done that.
like,
Obviously,
what the
this
hell
was
are
a
you doing?
Virginia warrant. But just to defend this warrant for 1 second, I think the court recognized in Scott, which is a case we cite in our brief, which is under the Wiretap Act, not directly a Fourth Amendment case, but the same principle applies.
Now,
That
there's value, isn't there, in our saying something like or deciding we need a warrant? It has to be particular as to time, place, time, and it has to explain the reasons why those limitations are reasonable, because that's always a part of a warrant search.
Got more
And
pushback on him than I was
wouldn't that have
expecting.
value
I
for the
like where
dispute
this is
that's
going.
going on around the country and between and among judges, even on this court? Some said some took your position that there's no right of privacy whatsoever and you don't need a warrant. Others have taken the position that you need a warrant, but you don't need much supervision from the magistrate judge. There is value in our setting the parameters of this process, isn't there?
I think if the court were to say something about warrants, that could have value, and I'm not going to claim that the sky is going to fall if we had needed a separate warrant at steps 2 and 3, and a total of 3 warrants. We've actually done that in more modern times. But what I am saying is that
More modern
caution the court
times.
against saying that that warrants can never include any kind of discretion.
Is
like the warrant
Sotomayor's
did
too
here,
old?
because
We don't need to say that.
You-
If all we said was, you generally need particularity, the way you do in any situation, you have to give enough to say there's a reasonable probability or
It's
fair
almost like you have to
probability, I
have
think is our
probable
language,
cause.
that evidence
Yeah, something like that.
would be disclosed.
That's
and what
crazy
is a
talk,
limited
Attorney Dye.
Search
I
to
know
these
it, I
times
know
and
it.
places, and you have to do it at each stage of
They
the
don't
warrant.
even need a judicial
Your
warrant
Honor,
to enter
I
your
think we
house
met
now.
all of those requirements here.
I don't even know if we need to go that far, but you would not be troubled by that rule.
Your Honor, you're simply describing what the Fourth Amendment requires, and
All right,
as
that's
we've laid out in
exactly
our
what-
brief, we think
that's
the Fourth
exactly-
Amendment satisfies those requirements. Our warrant satisfies those Fourth Amendment requirements.
I'm not quite so sure of that because you don't explain why it's narrow, but that's
Listen, my
Your Honor,
mom
if I
is the
could be-
most Republican lady I
Justice Kagan?
know, but I guarantee you, if she
Kagan, I'm
had
going to give you
seen
one of these
me
physical
or my
location
brother up there
hypotheticals that
talking
you're
to a
going to
judge
resist,
that
but you'll
way,
have a chance
she
to tell
would have
me why
smacked
it's
us
different.
herself.
But I want to
Yeah.
understand your theory, and the easiest way for me to do
Here we
it
go.
is
Kagan,
this.
come get it.
So let's go back
I
to
love
what Justice
Kagan.
Gorsuch said.
So
Let's
much
use
criminal history. I love
the
that for
storage
her.
locker. And there's a storage locker facility in town, has 500 storage lockers, and they have a relationship with the police chief so that the police chief can come to them and ask the storage locker manager to search all the storage lockers for particular things that the police chief needs. So the police chief goes to the storage locker manager and he says, we're looking for somebody with a particular kind of weapon. We're looking for somebody with a Glock. And the manager goes through each of the 500 lockers, and he comes back to the police chief and he says, I've got a list for you. We have 8 lockers that contain a Glock. And now we're going to have a further conversation, you and me, the manager and the police
hold
chief,
on, I
about
got you,
which of these
Oslo.
8
Give me
you
a sec.
really want. All right?
The Trump
and they do that.
administration believes
So
they have the
in that
probably cause
situation,
exception.
how many
I
of the
love you,
lockers would you
Oslo.
say have been searched? And how should a warrant respond to that? In other words, have 500 lockers
Most
been
of them
searched?
probably do bang
have
their
8
cousins.
lockers been searched, or have 0 lockers been
Yeah.
searched?
I think some of that might depend on
I'm getting ready for my
exactly the
live here, so I'm kind of
circumstances under
everywhere.
which the
No worries, hon, I got you.
proprietor of the storage facility was permitted to go into the storage lockers, because that might set some of the parameters of the reasonable expectation of privacy, or at least inform them. I also think
that
it's
would,
distinct
okay.
from the circumstances we have here, because you actually have someone who more plausibly could be seen to be acting as a government agent than the recipient of a warrant or a
No,
subpoena.
I guess what I'm saying is just assume that the relationship is similar to the relationship between Google and the government, and
They
just
can't all
assume that
land,
the terms
Oslo. I've
are
learned that
similar
the hard
to the
way.
terms that Google has with its customers. So all of that is the same.
So
500 lockers searched,
You
8
didn't see the
lockers searched, 0
videos?
lockers
Law and
searched.
Oslo are the same person. It's
Your
Loslo.
Honor, I think to the extent we're talking about physical objects that are put into
Somebody
a storage
started
locker
that rumor,
is
and I
expected
started
to
calling him
remain
Loslo.
locked, except when
Yeah, well,
a
that's what he
user
told
comes
me.
and wants to take something out of it. I think
Exactly.
you might say that was a search of all the lockers, because someone went in and looked in every single locker.
And so what would you need
Oh my
for
God,
a
it was
warrant for
Midwest
that
who
search?
started it. I
I think
forgot.
we need probable cause that there was going to
Who
be
started that in
a
RJ's server, and it
block
became a whole
in one of the
thing.
lockers, but I think
So you
I'm
couldn't
not-
get it for
I
all
am,
500?
I am uncertain that would be
Interrupting
valid for the
her.
reasons I was
Big
discussing
time.
with Justice Gorsuch, in that those might all be separate Fourth
His
Amendment
mama needs to
places,
come get him.
and we'd need specific probable cause as to each. I don't think that's
You don't have to tell
true
her about the
of
probable
the
cause.
database that Google maintains.
Midwest,
so what
I
is
need
the
you to
difference
get
in your
Dean
view?
Withers on
So I
the
think the
sponsorship. I
difference
want to go
in
fly and
our
see
view
RJ.
is, first of all, to the extent that I heard opposing counsel, and this is in
We're
their
trying to
brief,
start a rumor
to
and see if
suggest
it
that
comes
Google's
true.
database is quite large. I don't think that in itself is a problem. I mean, obviously, you could get a warrant to search a large house where
Is it
the rooms
obvious,
are
though?
accessible to one another, or a large file room, even if it's physically separated across multiple rooms in a facility. I think the main difference here is that
This argument's
and,
going
Your
longer
Honor,
than I
here
thought it would.
maybe am going to resist the physical analogy a little bit, but I don't think that these are the same thing as discrete storage lockers.
Can't talk to them like they're
These are more
stupid,
like
dude.
storage lockers that don't have the set of expectations that I was just positing in answer to your hypothetical, and really are like a bunch of storage lockers with a glass wall. You could imagine, Your Honor, a coat check where we know that somebody dropped off drugs at the coat check, and we
I'm
know what the
assuming she's
person's
rolling
name
her
is,
eyes
we don't
right
know
now.
the coat check number. On their view, we couldn't get a warrant to go look at all the bags for the ID
Swear to God, this guy never
on the
shuts
bag
up.
that was for the ID matching the person who dropped off the bag, because those would be unnatural bag searches that would be unlawful under the Fourth Amendment, and so we'd wind up searching everybody's bag. I think this is somewhat addressed, somewhat obliquely, I suppose, by the citation we have on page 44 of our
Digital
brief
storage
to
is the
Chapter 8 of
hypothetical
Professor
bag,
Lefebvre's
you
treatise,
fucking
which
asshole.
allows for
We have
even
historical
in a
law
bailment
going
situation, we
into
don't think this is
luggage.
a bailment situation, but even a bailment situation, there's general agreement among courts that
Maybe Trump was actually chanting
bailee,
words.
the person
Jesus.
with possession of the property, can look
Oslo.
at it
Goddamn.
on behalf of law enforcement within the
Well,
terms
Midwest is
of the
calling you
bailment.
out.
And here, what you have, again, we deny that it's a bailment. But if you want to analogize this to some
I'm
kind
sorry,
of bailment
Midwest.
scenario like you might have with the storage lockers, we'd
I'll
still
do
be
better
within the
for you.
terms of the bailment.
Accountability
because Google
Live,
wasn't doing
3:30
anything
Friday.
other than stuff that
Educate
Google could
yourself.
already do.
Thank you, Mr.
I'll do
President.
better.
Justice Gorsuch? Justice Kavanaugh?
You always get a warrant, you said, and the states always get a warrant. So in terms of practical problems that would ensue, I gather there would be no practical problems. I understand your legal theory, but no practical problems from our saying that a warrant is required. Is that accurate for these particular kinds of warrants?
Your Honor, if the court were to say that this warrant was fine, we have no.
I'll be RB. I'm just take a quick potty break real quick.
Well, I mean, Your Honor, I think it is a huge
The
caveat.
question was, are there any practical problems that you want to identify?
Having us not taking any crap today either.
Yes.
I don't.
And I assume the answer is no, because you've many times today said we always get a warrant in response.
That's right,
so
Your Honor. My answer is no, but I would worry about an opinion that.
How we say that, I get that.
Well, what you say.
Yes.
But like, I don't think we've had practical problems getting the warrants we need in these cases.
And then if a warrant's required, it comes down to how particular, I think, correct? It has to be in describing.
I do think.
And on that, I just want to, I think you're going to agree with this, but I just want to get this out there and you tell me, there's a big difference between the issuing judge and the reviewing judge. That's the good faith. And the issuing judge, it seems to me, we should set some parameters, reasonable temporal scope, reasonable geographic scope, but then we trust issuing magistrates around the country to implement those rules.
Thanks,
when it comes to
Nani.
the reviewing judge,
Well, the
we
gummy
don't
bear.
micromanage and second guessing what the issuing judge did so long as it doesn't exceed, certain bounds that we've set forth. Is that correct?
Yes.
And what should we say if we say reasonable
coming.
temporal
He's coming
and
for this guy.
geographic bounds for these kinds of geofence warrants? Is that all we need to say? Maybe you want us to say the ones in this case? Should we get into this case, or should we just say it has to be reasonable temporal and geographic bounds and send it back to Justice Alito's first question? We're at the reviewing stage, not the issuing stage here.
Your Honor, I think that would probably be the better course because I think what this court's centuries, frankly, of Fourth Amendment jurisprudence teach is that it's difficult to put a ton of meat on the bone of reasonableness in this context or probable cause or reasonable suspicion or any of these.
No worries.
Particular, how particular, is 150 meters
Kavanaugh's
okay,
getting mad.
200 okay? It strikes me
shocker.
micromanaging that's going to be problematic.
This is Chatrie via US. It's about geofence warrants.
From the reviewing court down the road, given what we've said, that reviewing courts have to be extraordinarily deferential.
Yeah, and I think
Or
the court could
your right to
direct some
privacy on your
attention to the
data.
magistrate about, not wanting
Perfect way to
as I was
describe
suggesting
it.
to Justice Jackson, drawing parameters that under local conditions are likely to turn up much more than the government needs. But
Exactly. If we say things like that, we trust the issuing judges around the country who do this every day to make.
You should trust them, Your Honor, and frankly, our incentives are perfectly aligned with theirs, because when we're seeking a warrant like this, we don't want more information than we really need, because that just increases the noise-to-signal ratio and makes these more difficult to actually find.
And why are you getting a bunch of
I believe there's some
information?
suggestion from opposing counsel that often these warrants get abandoned or quashed and they don't really turn up much evidence of crime, and that
So
may
we're
be
just turning
because,
out warrants and then we're just
some
like,
law
nah, my
enforcement
bad.
Agencies, I'm not
So
impugning any
less
specific
information
one.
on a
We have many
warrant
wonderful law enforcement
so that the
partners,
magistrates who
aren't
are
drawing
obviously
the parameters
stupid
narrowly
can't
enough to even help
get tangled
themselves.
up in
So
it.
Everyone's incentives are aligned here.
This is the craziest shit I've ever heard.
So you described Mr.
funny enough.
Minkowski's position as maximalist, but there's a risk of the government's position being maximalist the other way. And I think, two particular concerns are the ability to track into private residences, and you didn't concede that. The other is calendar, photos, email. Can did I understand you before to say that you are conceding that would be different and that would be a search?
Yes, and I do concede that tracking into a private residence without a warrant, I think, is a very, very difficult argument for us to make, and I'm frankly not sure that we would actually make it. I was simply noting that unlike in Caro, where the court held that we would have needed a warrant.
Sure, but you didn't rule it. You didn't rule it out.
I didn't want to categorically rule it out.
Right, but you are saying that you would need a warrant.
Amen,
for
Midwest.
calendar,
I've posted
photos,
way too
email?
much crazy shit in
That would be
Discord. I don't
search.
want them having access.
And let me, I'm happy
So
to.
the Carroll
explain
case
again
they're referring
why
to is
I
the
think that would
automobile
be-
search
I just
warrant
wanted to make sure we
exception.
had a crisp understanding
I
of what the
gotcha.
government's position was on that. So that's
Yes,
sufficient.
that is the government's position on both of those issues.
Justice Jackson?
Just really quickly, I think there's something
So
about
it's
the iterative
interesting as a
process
couple
that
of
may matter.
articles
And
I
so
read said that
just
this is
taking
probably
Justice
one of the
Kagan's
biggest
hypo
data
really
privacy
quickly
cases
for
they've taken up in
an
a hot
understanding
minute.
of what is
So
happening. Tell me if the
Absolutely.
government
Absolutely
thinking
is.
about it in this way. You keep saying this is like storage lockers with
Hi,
glass
Michael.
fronts, with a piece
What up,
with
Michael?
glass in the front of it. They
Hey,
don't
Di.
have
Hey,
solid
Cass.
doors. Anyone can look and see what's in there. So step one is the government saying, tell us if by looking at these lockers, any have bags in them that might have a
Yeah,
gun in them.
Bubbles,
Give
it
us the
wasn't
list
being
of the
discussed a
ones or
lot,
how
which is
many
interesting.
have that, I think is a sort of a step one concern. And then maybe step two is, once you've gotten that subset, open the lockers and, see if there's really a bag or feel if there's really a bag. And then step three is open the bags inside each of the lockers. I feel like there's something
Have a good day,
happening
Nani.
with the way in which Google is providing
Goodbye.
this information in response to the government.
Could work out your
that
stress.
may be
Oh my gosh.
requiring more
Yep.
probable cause or more particularity as you go along. So what is the government's thought about that?
Yeah, I don't know how long
Your
his
Honor,
Zoom court's
with my
going to go
continuing caveat
whenever he
that I
comes
think there's
back.
a limited utility in
Hey,
some of these
listen, little
physical analogies.
toadstool
I would kind of
dude.
resist
I'm doing my
breaking it
best.
down
You need
exactly
something
that
more?
Oh,
way.
no,
I
you're
think step
good.
one, if we
You're
want
good.
to use the gun
Law's
example,
in our group
step
chat,
one might
and
be
they're
more,
always
okay,
talking
you've got
nerd boy in
a
there.
glass partition here.
I
Tell
think
us
it's
which
adorable.
of them have guns in them. Number
Love
two
Law. He has
would
so
be,
much range.
okay, of that subset, continuing to look through the glass wall. You don't even need to open it for this because this is still stuff that is exposed to your view. Please tell us which of them have a gun and a box of ammunition. And then step three is, okay, for the
Oslo.
two or three you
Laszlo.
found, please tell us who's rented those storage
Do
lockers.
you agree that you need more to get to each step? I mean, here, what criteria did the detectives use to narrow down the list from the 19 to the 9 to the 3 that were ultimately there? And wouldn't a particularized warrant need to have some criteria in it to guide law enforcement at each of these stages?
Yeah, just
So,
a
Your Honor,
quick
with
note,
apologies,
tap
I
the
think I need
screen,
to
follow
take a
the
step
panel,
back
gift the
and
panel,
say
all the
that
shits.
I don't really view this as getting more particularized.
Oh my
I
gosh.
believe there was enough probable cause that the original warrant was, and the 19 people that turned up, probable cause to believe those people would be either witnesses or suspects. And then there's a question of how to figure out which ones to follow up on. So what you actually have here is a warrant that I think is fully particularized with probable cause the whole way through.
You could have gotten the 19 names from the beginning.
I think that we could have, but in order to maximize privacy, what happened here was that the warrant included a minimization requirement on the government at each step, which is akin to the kind of minimization requirement you see in the Wiretap Act.
Okay, thank you.
Okay.
Thank you, counsel. Rebuttal, Mr. Unikowski?
It's like you're
Fucking
done.
finally.
Thank you, Your Honor. So I'd like to say a few words about why this was a search, a few words about the warrant, and then finally why the court should decide the case. So first, why this was a search. I welcome
All
counsel's
right,
concession
love it.
from the podium that if there was a search for something like something else in the cloud, like email
Definitely
or calendar
smart
entries
enough
or
to be more
photographs, in that
respectful.
case, there really would be a search and a warrant would be needed. But although I welcome that concession, I just don't understand the distinction that is drawn between those types of data and this type of data for Fourth Amendment purposes, either under a property or a privacy lens. So under a property lens, a person's relationship to their location information is the same thing as the relationship to their photographs or to their email. It's in their password-protected account. Counsel suggested that the answer might be different because it's in some way raw data. It's sort of generated by your phone as opposed to sort of a creative writing. So first of all, it's generated by the person in the sense that you move around. And second
I
of
wonder
all,
if they're
I don't
going to pull the
understand what that distinction
Zubalaki
has
case
anything to do with
in.
the Fourth Amendment. Just as an example, your Fitbit
think
or your
it got brought
Apple
up.
Watch might measure your
Oh,
heart rate,
earlier.
and that
Okay.
information might be transmitted into the cloud. I still think that's yours, even though it's generated by your autonomic nervous system as opposed to the fact that you've written a journal. It just seems to me that if you have control over the data, you can turn it on, you can turn it off, off, you can delete it. It just doesn't matter if it's created by taking a photo as opposed to by the fact that you've decided to go somewhere. Similarly, from a privacy perspective, I don't see why a photo you take outside is somehow more private than where you were that day, because you don't have an expectation of privacy in like the thing that you were seeing if you were outside, but you do have an expectation of privacy in all of your photos, and likewise, you have an expectation of privacy in everywhere you've gone. So I think that if the court accepts the government's concession that you have an expectation of privacy or a property interest in photos and emails, the same thing would be the case for location history. As to the warrant, on the step one issue, Justice Jackson suggested that what happened here is that the government received a list of like 19 different people that were in the geofence, but respectfully, I don't think that's what happened. What it actually got is all of the movements of those 19 people within that hour stretch. So it's a little bit like going into 19 apartments and taking a complete inventory of everything in the apartment, but not disclosing the person's name. Because if you look at the record, like all of those granular movements for that entire hour were exposed. And so that's why I think that the Ibarra case is directly on point here. You don't have probable cause to search based on someone's proximity to the crime. What happened here is each person's, what we regard as a virtual storage locker, was searched solely because of their proximity to the crime. And because their movements within the hour were exposed every 2 minutes, that's different from simply identifying which accounts were within the geofence. It's really exposure of information about them. And although it's nominally anonymous, the record shows it's actually quite easy a lot of the time to figure out exactly who a person is based on a relatively small record of their movements. But look, I've heard some questions from the bench today about steps 2 and 3. There's clearly a constitutional problem with those steps. I mean, as Justice Jackson suggested, the warrant wasn't particularized. There's no criteria given for identifying those people. In terms of how to decide this case, I think it would be a very significant case, giving a lot of guidance to the bar, if the court says, 1, a search happened, and number 2, at step 2 and step 3, at a minimum, there was a problem with the warrant without reaching some of the broader questions about general warrants or particularization if the court is inclined to resolve the warrant question narrowly, because the government has a lot of very striking arguments on the warrant issue that can have significant implications. One is that Google wasn't acting as the government's agent, so it makes a difference that Google pushed the button as opposed to the police. Another argument that's made is that the fact that software is conducting the search is constitutionally relevant, which could have revolutionary implications when
software
AI is
designed
monitoring
by
everything
who?
we do as opposed to a human being. Also, the argument that as long as something is nominally anonymous, that makes a Fourth Amendment difference, which also can have radical implications when de-anonymizing someone is very easy. So, like, all of these arguments that the government is using to defend the earlier
That was a point that was brought up Midwest. They changed something in, I think, 2023, and then I'm wondering, is it settled on mootness?
And deciding the warrant issue
like,
narrowly,
since it's no
and
longer
also
an issue
deciding
in
that to
this
search,
case,
that would be
right?
more
Like,
than a
I'm
broad
wondering.
enough opinion to be useful to the bar.
Future
and I guess on the final question
importance.
of whether the court should decide the question presented.
Yeah, no,
look, it's
I
very hard
agree.
to
I
see
just,
how the court could decide
I was
a
kind of
question
seeing where
like
they
this
wanted to
outside
go
the
with
context
that.
of a motion to suppress. If the court says the good faith exception applies here, it'll apply in every single case. I mean, Justice Alito posed the question,
I don't
well, what
think it
about all the
should.
other people, the 500 million people who were searched? Well, number one, they're not told. All of these warrants are sealed. The reason the outcry doesn't exist is that no one knows that thousands of times per year their accounts are being searched. Second, a 1983 claim by any of those people against the detectives would clearly fail on qualified
Civil
immunity
rights
basis.
lawsuits.
So really the only way these issues will be litigated is through a motion to suppress in a case exactly like this one. And this is a good vehicle to decide the case.
The
because
sad
there's an
part is that
extensive
most of these
evidentiary
people don't
record.
even know
There's
that they fall under
declarations
this.
from Google, there's live
Exactly.
testimony from Google. You'll never have a
Like,
case with a more detailed
I could be
account of the
geofence
technical
or I could
aspects
be
of the case
part
than
of a
this one.
geofencing
And so that's why I
warrant
think
and
the
have
court should decide the Fourth
no
Amendment question in this case.
knowledge of it.
Thank you,
And then the
counsel.
question
The case is
is,
submitted.
how far does the government go with this? Like, I
Right.
mean, I know we get into a lot of these slippery slopes, like they're going to start making lists or they're just going to do this for any reason. But in this government, it's not that unreasonable. I don't think it's crazy to think that, like, hey, we need our data under control as well.
Yes. Well, actually, I think it's the most important thing, in my humble opinion, with this administration. They're collecting all the information. They're getting all of the names and the places and the, things that they did. It's a lot. It's a lot of information. It reminds me of the Germans a little bit.
Yeah, like, just me personally, I don't want the government to know that, I don't know, let's say it's some geofence within a mile of my house, that I went to Kentquake in my house and the car wash and, like, there's just a couple of places that are close to me that I can think of. Like, Oh, the background target. Sorry, we're going to the next case, which if you've ever heard of Roundup Weed Killer, that's what this
Ooh,
case is about. Monsanto v.
Monsanto.
Durnell. This is about I can't understand, or I can't remember what FIFRA stands for. It's about pesticides and certain things that they have for unalivers of bugs. Sorry, I'm trying to figure out how to state this in a TikTok friendly term.
You're doing great.
And then like state law and whether it preempts, and then it's dealing with labels, people that got cancer. I have 2 family members that got cancer from that's directly related to that. And then the EPA and Monsanto negligence. This case is just all over the place. There's been multiple cases involving this, but I'm going to watch this out of special
We'll
interest.
hear argument next in case
Here we go.
24-1068.
I'm going to have to run.
No, you're
I'll
good.
be doing
You're
my
good,
live in
Ty.
a little bit.
Mr.
Oh,
Chief
so good to
Justice,
see you,
and may it
I'll
Cass.
see you
Have a good
soon.
one.
Bye,
Respondent's
hun.
label-based failure to warn claim is preempted twice over. First, it is preempted by the express terms of FIFRA's express preemption clause, which forecloses state labeling claims that are in addition to or different from those imposed under FIFRA. Here, a Missouri jury imposed a cancer warning requirement that the EPA does not require. That additional requirement is preempted. Now, respondent concedes, as he must, that the state tort law is a labeling requirement for purposes of the preemption clause. Bates held as much. Nonetheless, he insists that unless Congress expressly directs the agency to bind the judiciary, then the requirements that are imposed on a particular pesticide in the registration process and backed by criminal penalties are not federal requirements. That defies common sense, the statutory text, and this court's precedents. In particular, this court's 8-1 decision in Regal, where this court held that similar agency-imposed requirements on a particular device are federal requirements for preemption purposes. The same result follows from principles of impossibility preemption. The EPA regulation and the government's brief here makes crystal clear that a registrant cannot change the safety warnings on a pesticide label without approval of the agency. Thus, Missouri law here requires something that not only is not required by federal law, but that federal law doesn't even allow.
Well, how dare a
Either way
state
you
law
come
make
to it, either via
federal
express
regulations
preemption
more
or
strict?
impossibility preemption, the result here is clear. Congress plainly wanted uniformity when it came to the safety warnings on a pesticide's label. Ignoring Congress's clear direction here would open the door for crippling liability and undermine the interest of farmers who depend on federally registered pesticides for their livelihood. I welcome the court's questions.
Mr. Clement,
Thomas.
just for clarification, you seem to focus more on the label requirement in your brief and your argument, and
Thank you,
respondent
Bubbles.
seems to focus more on the underlying statute, FIFRA. I could be wrong on that. Would you comment on that?
Well, I guess, Justice Thomas, I think about it as a level of generality debate. And I don't want to put words in my friend's mouth, but I think he says, well, you know, what's the conflict here? State law looks to whether it's misbranded. Federal law looks to it whether it's misbranded. And I think that actually mistakes the inquiry both on the state level and on the federal level. I mean, state law, at least the applicable state law here, really doesn't address labeling of pesticides. It's a negligence duty of good care or due care. The way that you get to actual pesticide labeling is a jury applies that general tort law to a specific device and then decides a particular warning is necessary. In the same way, on the federal level, you don't look just to misbranding in the abstract, but there's a process to take that down to the concrete. And that process at the federal level is the registration process, where the agency can't even register the pesticide unless it makes a determination that the label complies with the statute.
Well, I think
I want to be clear here, and I'm sorry to stop this because it's all important, and I'm not saying it's not. But I want to just point out that this is the exact same Supreme Court that said last year that states could require that corn sites had to ID verify people, but now I want to see how this goes. That states could require that these corn sites made sure there was ID verification, but I'm curious how this is going to go. This is weird. Listen, there's more complexity to that, but on a baseline, that's what I'm looking at.
Of FIFRA's preemption provision, just like the language of the preemption provision from the medical device amendments that were at issue in the Regal case, both of those uses the word under, and I think that word textually captures the various requirements that are imposed at a device-specific level or a herbicide-specific level in the context of the registration process.
Look, if the states want to make you slap a label on there, I don't get the
that
problem.
A product that has been registered can become misbranded, right?
Don't they do that for some products in California?
For a registered pesticide or herbicide to become misbranded is to omit something from the label that is required by EPA in the registration process.
So you mean they just don't follow the process? But are you saying that if new information comes out in the 15-year interregnum between registration and re-registration that casts doubt on the efficacy or the safety of this product, you could have a product that is misbranded even though it has been registered and initially labeled properly, correct?
So I would take issue with that with respect to safety. Efficacy, as I think you know, is different, and that's why I think the Bates case is quite distinguishable, because the agency actually doesn't have to evaluate efficacy.
It's encompassing a lot of different factors, and I feel like I would do it an injustice if I were to lie to you about it.
First of all, the registrant has a statutory requirement backed by criminal penalties to bring adverse information to the agency.
No, I understand how it is brought to the agency's attention under the statute. What I'm asking is, could we have a world
Bubbles, I'll pause it real quick only because I can read this off to y'all. I'm sorry, guys. I know it's a little bit of a second, but I'll read it off to y'all. The Federal Insecticide, Fungicide, and Rodenticide Act creates a comprehensive regulatory scheme governing the use, sale, and labeling of pesticides. The act preempts any state requirement for labeling or packaging in addition to or different from those required under FIFRA. For decades, the EPA has exercised its authority under FIFRA to find that Monsanto Roundup product line and its active ingredient, glycophosphate, do not cause cancer in humans. Consistent with that understanding, EPA has repeatedly approved Roundup's label without a cancer warning. FIFRA prohibits Monsanto from making any substantive change to an EPA-approved label unless it first obtains the EPA's permission. Respondent is one of more than 100,000 plaintiffs across the country that nonetheless seek to hold Monsanto liable for not warning users that glycophosphate, the active ingredient in Roundup, causes cancer. The federal courts of appeals and the state appellate courts are divided over whether FIFRA preempts such claims. The Third Circuit has held that it does. In this decision below, the Missouri Court of Appeals joined the 9th and 11th Circuit and state appellate courts in California and Oregon in holding that it does not. The question presented is whether FIFRA preempts a state law failure to warn claim where EPA has repeatedly concluded that the product is not required and warning cannot be added to the product without EPA approval. I know it's a whole mouthful.
Could the
I'm sorry.
But there's so much to this that
for misbranding.
that's why I wanted to read it out. Basically, can they move forward? And also,
absolutely. But it wouldn't be a misbranding action. It would be a criminal action or a civil action for violating your specific requirement under 136D, I think it is, to keep the agency updated. And I think that's important, of course, because that would be the federal government essentially making sure that its registrants are continuing with their ongoing obligations. And that would sort of be more consistent with the thrust of Buckman, where if you have a situation where your concern is that somehow the registrant hasn't done something they're supposed to do vis-a-vis the agency, you give the agency the ability to take care of that. You don't say somehow you're going to put that all in front of a jury, and the jury is going to determine not just how this should be branded, but also whether or not the registrant kept the agency sufficiently up to date.
But
What if?
Go ahead.
What if the agency, EPA, says we've got this new information and we're viewing it, we're reviewing it? As soon as we get to a point where we feel comfortable recommending something, we will. In that situation, the state can't make a determination that, well, we have this new information, so that it's perhaps the EPA's determination of the label shouldn't be given such determinative effect. In other words, it's not necessarily the case that they're doing something inconsistent with what EPA would do. It's simply a fact that they're responsive to the new information more quickly than the federal government is.
Well, if they're more responsive than the federal government, and the way they sort of manifest their responsiveness is to mandate an additional or different labeling requirement, I think that walks them in directly to the plain text of the express preemption in FIFRA. And I don't think the situation's any different for purposes of medical device amendments in this court's decision in Regal. You could have the same situation where there's additional information that comes to light, and there are processes for getting all of that in front of the agency. If the agency takes its time, and it might want to take its time because it's charged with the responsibility of looking not just at sort of how the new information affects hazards and the like, but also how it affects the alternative pesticides, how it affects the overall dynamic and the rest. I think you want to give the agency the time to do that. And I think in that respect, it's important that when, the real way to deal with it, I think, would be if you think the agency's not being responsive enough, is to initiate a cancellation proceeding.
Well, I mean, how is that consistent with 136A-F2? It seems to me when you're saying, well, the state can't do anything about it, it's because you're relying on the registration.
Well, no, I don't think so. I think you're relying on the entire registration process. But I do think with respect to F2 in particular, I mean, first of all, I think the first problem with relying on F2
this is the Roundup case. I'm sorry.
I
thought I was talking. I wasn't.
That F2 actually, as written, really, as I read it, is only limited to EPA enforcement actions. Because what it talks about is that the registration is in no event a defense for the commission of any offense under the subchapter. And that offense under the subchapter, I think, does talk about an EPA enforcement action. And I don't think even a non-preempted state tort suit is an offense under the subchapter. So with all respect, I think F2 is a bit of a red herring here. I do think, though, as long as we're looking at F1 is actually the more relevant provision here.
Yeah, I have two family members who got cancer associated with Roundup.
They can't change the label without the agency's approval.
Even though they say it doesn't.
If, just supposing that EPA can bring a claim against you for misbranding and seek criminal and civil penalties despite a properly registered item, how would it be inconsistent with FIFRA to allow state tort suits to do the same thing?
So it would still be inconsistent with FIFRA and the plain text of the statute to allow a state tort suit to do the same thing. And if you imagine a situation...
Yes, why is the question?
So why is because there would be a grave risk, and I think it is manifested in this case, that the state requirement would
I don't
be
like him
different
as a
from,
person.
or in addition
assuming it's the same.
But he's funny as hell.
Even if you assume that it's the same, I think that you have a problem here, which is the idea would be that the state requirement would be to add something to the label. And under the plain text of F1 and the relevant regulations, 40 CFR 156
You okay, Michael?
70 sub C and 152.44 sub A, those provisions say that the registrant cannot change the label with respect to state
That's really what it boils down to then for you. It's not that you can in fact have misbranded but registered items, and EPA can seek remedies against you. You're just saying nobody else can do the same, even if it's the parallel proceeding, no additional requirements.
Yeah, because fuck them kids,
you have to go through processes.
We
to
don't
amend the
care
label.
if
So
we
is it kind
poison
of
people.
this
We
really
just
boils down to the
don't want
impossibility
anybody but the
argument,
EPA
doesn't
to
it?
be able to come
Well,
after
I
us.
think they're closely related. I think they're slightly different. I mean, part of it is like you've asked me to assume something, which is that the FDA,
Later,
the
Michael.
EPA rather, would go after us for misbranding. I don't think the EPA would ever go after a registrant for a misbranding that was based on the failure to
Sorry, y'all,
include
my
something on the
lives are
label
not for
that
everybody.
EPA itself says that they
I
can't
nerd out.
unilaterally add to the label. So I just so maybe EPA would go after a registrant in the context of some efficacy claim or something like that, where EPA's position is the registrant is perfectly free to change the label. But where the arguments sort of come together is because EPA quite clearly takes the position that as to the safety warnings and the hazard warnings, those are things that the registrant can't change on their own.
Well, with respect to that, if it all does boil down to the impossibility idea, that it's hard to add to these labels without EPA's permission, what do we do about the fact that, at least as briefs before us suggest, that registrants have added cancer warnings to their labels?
Right
without
on,
EPA
Bubbles.
permission
It's
or
Laws
objection?
Discord.
So
I just use
I
it
think
for all my
those are,
stuff.
essentially just a couple
This is
of
my
episodic
boss
things
right
that
below
the
me,
EPA
so
itself
we just use the same
addresses in their
Discord.
brief and
But you are
says
more than
were essentially
welcome. Post as
implementation
much as you'd
mistakes.
like.
I
I'd
mean,
like to
there
get more
may be
energy in there.
Slight quibbles about kind of each one of them and how they came to pass. One of them I don't think was actually construed by the agency as a hazard warning.
Oh
so
yeah,
maybe they
if you're
thought
not
that something,
following
was
law,
more of a
everybody
controversy
follow law.
warning
He's in
about
Zoom
Prop
court right
65 or
now, but
something
he's
like
an
that. And of
amazing
course,
attorney on
in
this
fairness,
app.
this
So
is
give
not
him
a
a
situation
follow.
where the EPA has always had exactly the same interpretation across administrations.
I spot you that.
Yeah, no, exactly. But I do think, my short answer to your question is to the extent that was ever allowed, it's actually flatly inconsistent with the EPA's regulations that haven't changed across administrations. And I think those are worth looking at carefully because they are unambiguous. I mean, 40 CFR
Teddy, what up?
44A and 156.70C, and that one is just absolutely unambiguous. You as a registrant cannot change your safety warning. Full stop.
If EPA came after someone for the label after telling you what must be on the label and saying you can't change the label legally, I mean, that would seem like a due process problem or something where the agency says you have to do this and then sues you for doing what they told you to do.
I completely agree, which is why I resist the idea that you could have a pure misbranding claim brought by the agency against a registrant for marketing the product with the EPA approved label that EPA tells you can't change.
Even in a new evidence circumstance, I feel like I understand your argument with respect to the T1 registration. EPA's looking at the label. It makes a determination on existing evidence. But there's a 15-year window between when that product has to be re-registered again.
Thank you, Bubbles.
And
I appreciate you so
Lots of things
much.
can happen in science in terms
I
of
hope you stay
developments
safe.
about the product. So if the product can become misbranded because of new information, I guess I'm just wondering why you think that you couldn't have a situation where it would be perfectly rational for either the EPA or the states to bring to the attention of that manufacturer this new information and process a claim related to it.
All of that
I
can
agree.
happen, but it doesn't become
that was landed.
misbranding. What happens is that information, first, the registrant has a statutory obligation backed by criminal
that you got your
penalties to bring
degree
it to the
and
attention
you know
of the
every
agency.
fucking thing.
And then second, anybody can initiate a cancellation provision and get judicial review under 136N, and the government has taken the position here that that's subject to judicial review.
Thank you, Counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
I just want to pin down the area of dispute because I, too, believed that misbranding and
Sotomayor's on my
registration
shit. Like,
were
there's
not
too many
inconsistent.
overlapping
A claim
areas
by
of dispute
Fairfax
here.
that someone has mid-branded can come even when registered. You're taking the position, I think, that misbranding would be limited to things that are not covered by the registration, meaning you change the label, you add something to it, you change it in some way, correct?
Correct.
You are, I think, answering Justice Jackson and Justice Kavanaugh, I think, by saying, if it's a failure to warn of something you should be warning, that would not be a misbranding claim. It would be a violation of a FRIFRA obligation to disclose that information and ask for a change.
Absolutely. And I think that way of looking at the world makes the whole
There's
regime
too much dog shit going on here.
mirror the medical device amendments regime, but also makes it work a lot more sensibly, because otherwise what you're basically telling a registrant is they can go through this whole process which exhaustively considers not just the product and its active ingredient, but all in conjunction with the label to make sure that it's safe and effective as used and has like a danger label if it needs it,
I'm
or
gonna
a
tell you
caution
right
label
now,
if it needs it. They go through
do
all
not
that
use
process,
Roundup.
and then the next
Just
day
don't.
they market it as labeled, and they could have that all be subject to a
Just
misbranding
pull those
claim.
I
fucking
think
weeds.
the problem is 136AF2, because it also says a valid registration, however, is prima facie evidence that the pesticides, its labeling and packaging comply with the registration provisions of FRIFRA. But it's prima facie, it's not presumptive. And so it seems to me if it's prima facie, it could be rebutted that FRIFRA could come in and say you misbranded because you failed to tell us about this risk.
So misbranding isn't the only offense under the statute, and there's a specific criminal penalty for failing to comply with your obligations as a registrant under that. So if you have a hypothetical registrant who has some terrible information that comes out that they're obligated under the statute to give to the agency, and they withhold it, they are certainly subject to criminal penalties. But it's not a misbranding claim. And I think it's a mistake to think all the different ways that a registrant can violate
It's just a
FIFRA
criminal
all
penalty,
come down
not
to
a civil
misbranding.
one.
I mean,
Don't worry
misbranding
about
is just
it.
one species. And of
They
course,
just
the most
didn't tell you it
obvious
would kill you,
violation,
you know?
and this is why there isn't this inconsistency between registration and misbranding. The most obvious way to commit a misbranding
Sorry, no, that's not the
violation
argument,
is
but
to
that's all I
omit
could think
something
of.
from the label that you were told you had to put on it in the registration process.
How
That's
do
a
you
misbranding claim. And of course, it would only be prima facie evidence because you blew it. You misbranded.
We have two lines of impossibility
Misbrand
defense.
is
Pliva
nuts.
and Wyatt are also there. Doesn't the history we're showed about the manufacturer who added the California 50 proposition information without FDA approval, doesn't that defeat your impossibility argument? Doesn't defeat your other arguments, but why doesn't it?
That was the same thing I said earlier.
The agency has, you said,
They
by
fucking
error,
did it
whether it's
anyway.
error or not, they've permitted this to be done.
So I don't think, my answer to that would be, I don't think Pliva and Bartlett come out differently if you could point to a couple of generic manufacturers who ultra-virus, and in a way that they actually weren't allowed to, tried to change the label on their generic pharmaceutical. I think that would have actually made those generic pharmaceuticals mislabeled, if I understand that regime, which is why it didn't happen. But I think you look to the law. You don't look to whether somebody essentially did something that was ultra-virus. And if you look to the law
hell
here,
no.
this is, and the government flat out says this in their brief, this is really analogous to the generic labeling regime, not the branded regime.
Thank you.
Justice Kagan?
And Mr. Clement, not to say you're wrong about your view of the scope of the misbranding actions, but if you were wrong, how would it matter? Could you still win if misbranding actions were more expansive than what you're arguing?
I mean, I suppose I could, and I suppose like you could, kind of just go with impossibility preemption and make this like very simple, because I just think you look at those regulations and it makes it clear we can't change the label. The reason I'm sort of fighting on this, and the reason I think I'm not wrong, is because I think
We
that
just
there,
couldn't
as I
possibly
said,
tell you that
when
there's
it
shit
comes
that
to
kills you on the
misbranding,
label
that's
in there.
very specific. The easiest way to commit
Sorry,
a
I'm
misbranding
fucking-
offense is to
this just
omit
agitates
something
me.
that you're required in the registration process to put on the label. If you omit something, and if of course the state thinks you need to add something that EPA is not requiring you to put on the label, I mean, that just walks squarely into the text of the express preemption clause. And part of the reason I'm kind of like resistant to put all the weight on impossibility preemption is because, in some respects, the express preemption clause is even broader because it doesn't require an actual conflict. if the state imposes a labeling requirement that's different from or in addition to, that's still preempted by the plain text of the statute without really regard to whether it's misbranded. And it seems to me that if EPA, once you go through the registration process, they tell you what's required to be on your label. And there's really no way to look at this case and not come to the conclusion that a Missouri jury has told us that a cancer warning
I get that they
EPA
tell you
hasn't
what's
required us
required
to put on the
to
label
be on your
is
label.
required to put on that label. And that just seems like a requirement
But does it
in
limit
addition
what
to,
can be put on the
what's
label is
required
the
by
better
EPA.
question.
And if you can get there without saying the word misbranding or thinking that, I have to be right about that, I'm totally fine with that. I just happen to think that from the perspective of my client, I guess what I would say is this. We go through that entire registration process. The way I would understand that is the agency is giving us a green light that we can then go forward and market a pesticide or a herbicide as labeled and not have to worry about a misbranding offense. We got to respond to all the other statutory requirements. And again, that's exactly parallel to what happens in the medical devices amendments case. Once you get that device and it's approved with labeling, you can't deviate
Then
from
fuck
that
them
labeling.
kids, man.
And if there's additional science that comes along, you got to get the agency apprised of that. But you can't be held liable in state court for marketing a medical device that's labeled exactly like the FDA told you to label it. And I think the same thing should apply under this statute.
Justice Gorsuch? Justice Kavanaugh?
Just on that, there are ways, I think you're saying, that EPA can change requirements going forward. But if it tries to say you were misbranding when you did what they told you to do, that's a retroactivity problem of sorts in the sense that they're penalizing you retroactively for something they're saying is now required that they didn't say was required before, in fact, was prohibited before.
Yes, and I actually think the retroactivity frame is a helpful one because if you look at this statutory scheme, the real way you sort of change warnings or take a pesticide off the market is through the cancellation proceedings. And when the agency actually goes through the cancellation proceedings, there are requirements. They're supposed to allow the manufacturer, except in extraordinary cases, to continue to sell the existing stock. They're supposed to make a specific analysis that takes into account the reliance interest of farmers and other users. And all of that kind of makes sense that if you're going to sort of prospectively take something off the market, you go through an orderly process. And one of the anomalies of allowing a state tort remedy to be essentially a requirement is it does have this kind of retroactive effect to it. And I think that's what makes it particularly problematic here.
And I think you just covered this in part, but to Justice Jackson's good point about new science, you're saying the way you account for new science is on a process that changes the requirements going forward, not on a process that retroactively tells you that what you did yesterday as ordered by EPA is somehow illegal.
Absolutely, and it's an agency process that takes into account all of the various factors, costs and benefits. And of course, the agency has incredible resources at its command, including peer-reviewed panels, cancer review, and the like. And this case provides a perfect example of that. It's not like when this IARC study came out and said that, glyphosate, like hot beverages, is a cancer risk. It's not like the agency said, we don't want to hear about it. They exhaustively studied it, and they actually did peer review that IARC doesn't do. They looked at more sources than IARC did, and then they came to a conclusion that's shared by regulators around the globe that glyphosate doesn't have a cancer risk. It's not carcinogenic.
But that isn't the only conclusions they've come to. In fact, they found it's both inconclusive, tied, and not tied. They're all over the place.
But that is an important difference from this context and the medical device amendments context, which is, although they're worded similarly, the preemption clause in the medical device amendment sweeps in design defect claims, and here it's really just on the labeling. But the only reason I do hesitate is because it's obviously tempting in a world where you can bring design defect claims but not failure to warn claims.
Here's my problem is that any potentiality for cancer should be warned about. I don't give a fuck.
So with that caveat,
my grandmother got non-Hodgkin's lymphoma, and my dad has chronic lymphocytic
you put most of your weight on
leukemia.
express preemption, but obviously you do make the impossibility argument as well. How do you think about
maybe there's
implied
certain
preemption when there
genetic.
is an express
I don't know.
preemption clause present? it seems odd to move on to implied preemption. Wouldn't it all be governed just by the express
That's just
preemption clause?
fifis. This
Well,
is
this
not a
court has been
legal
very
argument.
clear, and this is critical, that you don't sort of say, well, there's an express preemption clause, and so that's the only preemption we're going to do here. We're not going to do any kind of implied preemption analysis or impossibility analysis. You've squarely rejected that, and I think you should do it here too. I don't think there's a huge difference between the two here. I think if you sort of think about this, like Regal was an express preemption case and just an express preemption case. But of course, when Justice Scalia decided Regal, he didn't have the benefit of Pliva and Bartlett, which come later. And so if he did, he might have said in Regal, well, this is both an express preemption case and an impossibility case. So I think both roads sort of lead there. At the end of the day, though, I kind of like text. And I do think we get there on the express preemption provision. And I do think that, in some hypothetical case, maybe not under this particular reg or this particular provision, but it's going to matter.
It may not be a
that the words
failure
in
to
addition
warn,
are there,
and
because
I'll
that
be
is,
clear,
at least in
just because
theory,
of
it doesn't actually
FIFA
require
and everything.
conflict
Like
at all for a
I'm
state
willing to
requirement
concede
be,
that.
preempted, as long as it's an additional
This is
requirement. That's
more
textually
just
enough
it's
for
a
it to be
personal
preempted.
case
Well,
for
yeah,
me
it
rather
seems to
than
me that your
a
impossibility argument is kind of wrapped up into the
anything I'm
express
looking
preemption
for a
argument, 'cause the
legal
whole reason
argument
it's
in. But
impossible is that
I'll just
you are
say that
required to
I
do that.
firmly
You
feel
can't
like
you can't change it,
anytime
and
there's
the
a
state
possibility,
is
there's a
prohibited from
duty to
requiring
warn,
anything in
and that's
addition to
again
or
not a
less
legal
than.
argument. That's
Yeah,
a
I guess
moral
here's the
one.
difference, though. Like, even if in theory we could change the label, I mean, we're still not required to in the registration process. And I still think the way I understand this is like, look, there's a broad general standard of misbranding. EPA looked at that and made it concrete in terms of this particular herbicide by saying, here's what you need on your label. A Missouri jury did the same process, took a broad standard, made it concrete to the same herbicide, and said, you need a cancer warning. And so under Missouri law, a cancer warning is required. Under federal law, a cancer warning is not required. That is a requirement that is in addition to the federal requirement, and that would be true even if we could change the label. So here, they end up kind of being coextensive, but I can imagine a world where they're not. In some respects, if you're concerned about the one or two outlying
I think the thing
examples
is,
where
who
somebody was
gives a
allowed
fuck?
to do a warning,
California
then the
requires
express
additional
preemption
warnings
clause
as
may
well
be a
for
little bit
certain
more
things.
impervious
Like,
to that objection.
they just want an additional
but again,
warning in
I
Missouri.
say we're happy
Give
to
it
win
to
either
them.
way, but it's
Or
hard not
don't
to
sell
like
your
the
shit
text.
there.
Thanks.
Justice Jackson?
So I guess I'm not sure that retroactivity in the questions that you explored with Justice Kavanaugh necessarily captures all that's going on here. And I worry a little bit about the way in which you are describing this and its seeming inconsistency with what we said in Bates.
Preach.
So I think that one way to understand this scheme, the statute scheme, is that there's a registration requirement and there's a no misbranding requirement. And every 15 years, EPA makes a registration decision that sets the requirements for a pesticide's label based on the information that EPA has considered at that time. But in the years between registrations, the company still has to comply with the no misbranding requirement. And I guess I'm trying to understand why it couldn't be that both the EPA and state tort law can enforce the misbranding requirement in the interregnum. So, I mean, I think in Bates we said that FIFRA contemplates that pesticide labels will evolve over time. And we said, quote, tort suits can serve as a catalyst in this process. And you can see how that happens, right? When new information comes in that 15 years, the threat of tort liability is one thing that spurs the manufacturer to go to the EPA and make sure that they're giving them the information.
Handle your business.
But it also enforces the no misbranding requirement. So why isn't the kind of concept of the way the scheme works, as we laid it out in Bates, how we should be thinking about it? It's prospective, not retrospective in that sense.
So let me try to use Bates as an
I
example
love that
of
framing.
answering your
She
question.
slayed
So
with
one thing
that.
I think Bates was clearest about is kind of the clearest example anyways that Bates contemplated of a conflict that would trigger the express preemption provision is federal law says for this particular pesticide, all you need is a caution label. And state law comes in and says, no, for that pesticide, you need a danger label. Bates says that's a clear conflict. Well, how does EPA decide that a particular pesticide needs just a caution label and not the more serious danger level? They do that in the registration process by examining the toxicity of the substance. And then they say, all right, this is sufficiently non-toxic that it just requires a caution label. Now, let's say 5 years goes on and somebody with some new science goes in before a state court jury and says, actually, EPA got it wrong. This thing is more toxic than they thought. And so under Missouri law, you need a danger label. I think that would still be clearly preempted by Bates. And the fact that you could tell the jury you need the danger label in order for the product to be not misbranded would not change anything.
No, I understand, but isn't there a world in which that is a different circumstance because the EPA has not yet considered that information? So you're not actually conflicting with, you're not doing anything different or in addition to the determination that the EPA had made based on the information that was before it. I guess I see that, I mean, it's nuanced for sure. I mean, the way you're saying it is pretty straightforward, but you're reading the express preemption statute as though it says such state shall not impose or continue in effect any requirements for labeling or packaging, period. And this says in addition to or different, which suggests that there could be a parallel state enforcement proceeding happening.
Well, I guess I would answer by saying only a completely parallel regime. So if they want to say that, you know, if my client omits something that EPA has said must be on the label, and somebody gets hurt because that warning's not on the label, then you can have a tort claim that's a failure to warn claim that basically is a negligence per se claim. So basically,
how are
that
we
level
reading
of generality
sort of
that says you're liable because you didn't follow the federal requirement, and we are going to give you a state remedy. That's why it is in addition to or different from. It's not. We're not striking those words from the statute. And the one thing I would say is if you read Bates carefully, at the end of the opinion on this point about tort suits can get information, there's a block quote from a Court of Appeals opinion. And if you actually read it carefully, what the court says by quoting that is these tort suits could generate information, and then people could go and ask EPA to allow the registrant to change the label. So even in Bates, there's a recognition that there is not this unilateral ability to change the label, at least with respect to safety and warnings. And I would say this is where my answer that you can still have design defect claims. Yeah,
that you got your degree,
because that could be part of the process where additional information is generated and ultimately brought to the attention of the agency. This is a narrow but critically important preemption clause. It focuses on label-based failure to warn claims, and that's exactly what this is and should be preempted.
Thank you.
Thank you, counsel. Ms. Harris?
Okay.
Mr. Chief Justice, and may it please the court, many paths lead to preemption here. The simplest is that state and federal law impose different and indeed conflicting labeling
I
requirements.
think I've heard her in front of the court before.
Missouri forces petitioner to add cancer warnings or face tort liability. But federal law requires petitioner to stick with the label EPA approved in registering the product unless EPA approves a change. EPA registers pesticides only if EPA approves their labels as adequate to protect health. Federal law then requires manufacturers to keep using that label. Manufacturers must apply to amend registration to change the label. Indeed, regulations provide specific statements pertaining to the hazards of the product must be approved by the agency. That's 40 CFR 156.70. Missouri thus requires adding cancer warnings, but federal law requires EPA to approve
Still
new
driving me
warnings
crazy
and
as
tasks
per
EPA
usual.
with deciding what label changes would mitigate any health risks. State law must give way. I welcome the court's questions.
Not saying he's not a good lawyer, but.
Ms. Harris, I asked you the same question as I asked Mr. Clement. It seems as though you are focusing on different things from the respondent.
He makes me want to punch things.
It's true we're focusing on different things. I would say we are focusing on the text, and both the text of the statute and the regulations, specific to how the misbranding mandate is implemented. So the text from which we are getting the do not change the label requirement, which I agree with some of the questions is central
I feel like
to the
I've
case,
heard her before.
starts off
Harris.
with 136AF1
if I
of
recall,
FIFRA,
she
which
was
says
good,
if you want to
but
change your
I
label,
need to
go amend
remember.
it. You have to get EPA's approval. EPA has to confirm it's not misbranded. And then
It's too
for
many
other
voices
federal
are going
requirements
together
in
for me.
Bates's framing, I would turn you to the regulations, which are not specific just to registration. They talk about how do you change your label. And so 156.70 is the clearest. It says for hazards like cancer, you have to ask for EPA's approval. And then there's a whole welter of other ones that reinforce that. And that makes sense because EPA deals with misbranding, both to prevent misbranding in what it actually has before it and to protect against people who might be, if state requirements that might be adding things that are misbranded by saying, no, it's all channeled to EPA. EPA has to review changes to make sure they don't confuse people. You really have to stick with your label to safely use the product.
So do you agree with everything that Mr. Clement said about how this regulatory scheme operates? And even putting aside the preemption question, is everything he said your understanding of how the agency works?
I agree with him. I would just add 2 refinements. One, he is correct that EPA doesn't go after people for, in a hypothetical world, if things change, would you have been in trouble for not changing your label even though EPA doesn't let you? That's right. We don't bring that kind of enforcement action. But 2, not only was Mr. Clement correct in talking about cancellation proceedings, if new evidence does come to EPA's attention, and again, we don't think this is a new information case because of the time periods involved, even if it were, what EPA normally does, let's say it came to EPA's attention, we think this product might cause cancer. The requirements for dealing with that under federal law are completely different from a state just saying slap a cancer warning on the product. What EPA does, and this is at 136 AD1 of the statute, and then a whole bunch of regulations at 152.170 of the regulations, EPA first says, what's the exposure risk for cancer? Then EPA next asks, are there different forms of labeling that you could use for protective gear that would mitigate the exposure? And then if that doesn't work, EPA says, are there different things we can do to the label to restrict the use to particular crops or say that only professional applicators can use the product? All of that, again, very different from the way that state law is processing it. And at the end of all of that, if EPA thinks that there needs to be a change in the label because it wasn't initially adequate to protect against that exposure risk, whether it's cancer, whether it's something else, but it can be solved for with these restrictions, what EPA does is not go after the manufacturer and say you're in big trouble now. EPA has a default 120-day grace period to change the label. Now, if there's an emergency, EPA can shorten that significantly, their suspension powers. But EPA, this is at 152.167 of the regulations, has the flexibility to say when your label changes. So in all of those particulars, not only is this a situation where EPA is controlling how to respond to a risk or new information that might change the calculus about what happens, EPA is doing so in a completely different way than just saying slap on a cancer warning and assume that that will sort of solve for the issue, because EPA is looking holistically not only at someone who might read the label and be exposed, but also at other people in the process and endangered species.
Well, and throughout that long process, in response to information that suggests there is
I think that's
risk
Roberts.
that's not on the label, the states cannot do anything?
The states can do things that add additional penalties, as Mr. Clement said, but what they can't do is try to sort of second guess or undermine this process. And I think that makes a lot of sense. Again, EPA is getting in new information. EPA is the one with suspension power. If you had 50 different states that are just like jumping the gun, Iowa says maybe this causes cancer. California says absolutely causes cancer. Some other state says this doesn't cause cancer at all, so put that on your label too. It completely undermines the uniformity of the labeling scheme.
Well, it does undermine the uniformity. I appreciate that.
I guess this is what bothers me. I've seen multiple times on warning labels where it'll say state of X and state of X require a warning for this. I'm wondering.
But what they have the power to do
maybe
is to bring suits to, you can petition for cancellation or find many other mechanisms of saying EPA currently has it wrong, spur EPA to action. What FIFRA does not allow is throwing
Thank you
preemption
all.
out the
I
window,
appreciate that.
throwing the express preemption clause out the window and saying states are perfectly fine to have a free-for-all because, again, FIFRA is designed to guard against both sides of the risk.
So the only thing that we need to worry about is the labeling, but the states can do anything else with respect to the particular cancer that they would like.
Well, isn't that what we do with everything
If I'm understanding
else?
the question correctly, states, with respect to labeling, cannot propose their own labeling. States, of course,
Government
remain
made
free to
CBD
restrict the
cool,
use of the
but it doesn't mean
pesticides under
states can't regulate it.
136A. So if a state said, look, within my borders,
Hemp
I just
and
don't think this
CBD.
pesticide's safe, don't use it, they're free to do that. What you can't do is
why can't they impose tort liability then? If they can stop the product from being sold at all.
Of course,
because
that greater power exists. Why doesn't the lesser power, without saying the label, we know we can't change the label.
Well, again, you could say you can't sell the product. What you can't do is countermand the judgment Congress put in.
About the label.
I will just be so real with everybody. I have no background in anything here. Like,
is the premise
I
of it
couldn't
just
even
a
begin
design
to
defect
tell you
claim?
what
I'm sorry
goes
not
into
to follow
this.
the question, but what
just a
states can do
special
is
interest
say,
of
If we
mine.
say it's so hazardous, we can ban it. Why can't we say it's so hazardous that there can be tort recoveries for it?
I think that would just be a sort of defective design suit, and it would go into what Mr. Clement said. Those are fine under Bates as long as it's not a label claim.
So those would be fine.
A design defect claim that is not masquerading as a failure to warn claim is permissible under Bates for the reasons Mr. Clement said and the reasons that Bates itself recognizes.
How does that petition for cancellation process work that you described to the Chief Justice? Can you lay that out?
Sure. People can bring petitions.
People, including states.
Sorry, people, I believe including states, there have been many brought by environmental groups, any other interested group. You petition to EPA to cancel. It's a way to test, is EPA...
Cancel the registration.
Cancel the registration. It then gets litigated out. There's judicial review of this process specified both in the specific cancellation provisions and more broadly in 136N of FIFRA.
Does that encompass a petition to change the label?
It could, in theory, be because you think that... if to cancel it, you could say it shouldn't have been registered at all because it's misbranded for whatever reason. Again, if EPA also thought that there was some sort of misbranding risk, like
Hey,
as a
Law,
practical
are you
matter,
back
what
for a
happens
second?
is EPA gets information and might ask the manufacturer, like, can you please change, can you please try to amend your registration?
Okay,
and
I'm
change
just gonna
it?
run
If
and
you
take
don't,
a
at that
quick
point, you
break
might
real
have
quick. I gotta go to the potty and grab a drink. I'll be right back.
Sounds good.
Okay,
denying
thank you.
petition for cancellation. Yes, the whole process is set off in 136N. It's the petition process similar to denials of registration. The whole, any final EPA action under 136N is judicially reviewable. It's a very prescribed process. And on top of that, I just want to correct some sort of any misimpression. The EPA is just sort of sitting on its hands, like every 15 years it springs into action. EPA itself does monitor new information. Whenever it comes to light, it often calls for information from manufacturers. Dacthal is a great example of that. That is a pesticide where EPA became aware of possible thyroid risks in unborn babies. EPA asked the manufacturer for information. The manufacturer was dragging its feet. EPA threatened to suspend the registration. The manufacturer supplied the data. EPA wasn't satisfied and said it was going to cancel the pesticide. It's now off the market. So I don't think this is a situation where there aren't sort of means by which people can bring information to EPA's attention. The whole point of the registration process and why it takes long is throughout like that process, EPA is often soliciting information from people to comment on interim steps in the decision. And so that's one reason it takes a while, honestly.
Thank you, Counsel. Justice Thomas, Justice Alito, Justice Sotomayor.
If I understood Mr. Clement, he was saying that even if the law permitted the manufacturer to choose to add a cancer warning, it would still be express preemption because the state would require it as opposed to giving the manufacturer choice. Is that your position as well?
I would just put a little refinement on that. I think that's probably correct as a conceptual matter, but one reason backstopping it is the process I described, where if EPA identifies a risk, it has a completely different process and sort of mitigation procedure for figuring out what kinds of warnings are adequate to guard against the risk. So EPA is very zealously saying not only yes or no, do you need a particular type of warning? But for that type of risk, what is the best way of making sure that not just the person using the product, but people who might have secondary exposure to it or endangered species get the information they need to ideally mitigate the exposure risk?
So what do we make from their 2022 statement where they were approving the California Proposition 65 label. Hasn't been withdrawn, correct?
Respectfully, that's from 2012, and that is a different.
I'm sorry, I misspoke on the.
It's okay. It's with respect to a different product. So I think you make absolutely nothing of it. We have said repeatedly ever since then that was an error. More relevant are two things: one law, one facts. On the law, Mr. Clement is correct that the label regulations could not be clearer. If you are doing something like a hazard warning, which I don't see any way of describing a cancer warning as anything other than that, you must get agency approval. That's what it says. That's 156.70. 2, on the facts, I would say the even more relevant facts for Prop 65 would have to do with glyphosate itself. Whenever pre-first Trump administration, people were using those warnings on glyphosate products, they were always submitting amended registration requests. The agency approved those. So even that universe of Prop 65 warnings, which again are just saying California thinks this might cause cancer, not this causes cancer, even those went through the amended registration process requiring EPA approval. Now, the first Trump administration said, that's misbranding, don't do that at all. And there's a lot of water under the bridge at this point because those specific warnings were invalidated on First Amendment grounds by the Ninth Circuit. But I don't think Prop 65 can possibly get responded anywhere, either on law or facts for those reasons.
Thank you.
Justice Kagan, Justice Gorsuch, Justice Kavanaugh, Justice Barrett, Justice Jackson.
Can I just quickly ask you about
Jackson.
Doesn't the statute contemplate that the EPA will approve label changes if they're consistent with FIFRA? So we're not talking about an arduous process here. If the manufacturer proposes a label change, I think the language of the statute says the registration shall be amended to reflect such a change.
But respectfully, it is very arduous because as part of that process, and if you look at the regulations at 156, it's the regulations at 156 onwards, what they say is you have to also submit data adequate to support the change so that the agency can go through and make sure whatever label change you're proposing, especially if it's a cancer or other hazard warning, is not itself misbranding, is consistent with FIFRA. This is not just a send me a quick letter, don't tell me why you want to change your label situation. Again, and that reflects these are regulations that are trying to implement the mandate not to have misbranded pesticides.
No, I understand, but it's the suggestion that, we can't do it on our own. It looks as though you pretty much can if you send the relevant information. The registration shall be amended.
Respectfully, I don't think the idea that just because you might think approval is easy in certain situations is enough. I think that would be directly contrary to Pliva and Bartlett, where the court said—
What about Wyeth? Isn't this like Wyeth?
No, it's completely different from Wyeth. There's a very stark contrast. For the changes to be affected regulations for the FDA for brand manufacturers in Wyeth, it really was you, brand manufacturer, allowed unilaterally to change your label for this period of time. FDA will then tell you if it disagrees. Here, it's the opposite. It is, do not change your label. Under no circumstances, change your label if it's a hazard warning, unless EPA says yes. And that is in the heartland of what Pliva and Bartlett said, which is, if your action depends on the approval of a federal agency in order to do it, then you are not able to unilaterally act for purposes of federal law. And when state law is telling you you better change that warning, that is a direct conflict, or in the words of Bates, relevant here, that would be different from state law.
Thank you.
Thank you, counsel.
Rebuttal.
Mr. Keller?
Oh, shit. Hold on.
Mr. Chief Justice, and may it please the court. You unanimously held in Bates that a pesticide can be registered and nevertheless misbranded,
We got a
even if it
Solicitor
uses the
General
label
here.
that EPA approved at registration. Yet Monsanto now asks you for the opposite holding, that Roundup cannot be misbranded as a matter of law because EPA found for the first time 50 years ago as a matter of fact that it is safe based on information Monsanto submitted. After 2 briefs and a lot of podium time, Monsanto still hasn't pointed to one word in FIFRA's text that says the agency's factual findings at registration create a requirement for labeling. That's because the text repudiates that proposition in no uncertain terms. 136AF2 is an anti-delegation clause. It says that the agency's findings at registration are nothing more than prima facie evidence of compliance with the labeling requirements.
Here for
Prima facie
it.
evidence is not a law of the United States made in pursuance of the Constitution. It is a thumb on the evidentiary scales that can be rebutted, and a reasonable jury has rejected that evidence. With no satisfactory response to 136AF2, Monsanto changes the subject, making the totally uncontested point that the express preemption clause talks about requirements under FIFRA. We agree. We're good textualists. We don't ignore prepositions. And we agree there are affirmative delegations of authority to the administrator to issue regulations that create labeling requirements. Monsanto's problem is they're not relying on any of those regulations. They're relying on registration and registration alone. There is nothing in, by, under, or next to FIFRA that makes the registration decisions that EPA makes binding labeling requirements with preemptive force. I welcome your questions.
Could you tease out your delegation argument and how that has the impact that has on preemption?
Yes, I can, Justice Thomas. I think a good example would be, imagine if the EPA had promulgated a notice and comment rule. It went through an entirely formal process that in the Chevron regime would have unquestionably satisfied Meade, saying Roundup is perfectly safe. There's nothing wrong with glyphosate. If you put any type of warning on glyphosate, we, the EPA, determined that that would be misbranded. In the old regime, I think you could say we're going to engage the fiction that Congress intended to delegate that power to EPA. We don't need some source of text saying that they can do that. I think in the new Loper-Bright regime, you would say, point to text delegating that power to the agency directly. Well, they don't have that notice and comment rule, but they're trying to rely just on 136A, the registration process, to say whenever the EPA approves the label at registration, even if it's from 1974,
no, this is an ongoing case with them.
It can't be anything other than that for purposes of misbranding. But nothing in 136A says that. Everything that the administrator does under 136A is textually linked to the administrator's power to register the pesticide. He shall register the pesticide or he shall not register the pesticide. He's not liquidating the meaning of whether Roundup is misbranded for all purposes. He's expressing his opinion on the matter. You heard last week the FCC case, and it sounds like some of you might be willing to say when the FCC issues an order saying pay hundreds of millions of dollars, that's just the FCC's opinion on the matter. It doesn't become actually the law until a jury finds the facts and enters a verdict.
That was a kind of a banger, I'm not going to lie.
There are other problems with 136AF1. You heard my friend on the other side and my friend from the United States saying that that requires pre-clearance for a label. I don't agree with that proposition. Look at the text. It says if the labeling is changed, past tense, then the administrator shall amend the registration. There's nothing that requires the manufacturer to wait for the amended registration. There's nothing that even requires the manufacturer, if the EPA says, no, I'm not amending the registration, to walk back the label change. The only thing that the EPA
actually don't know if RFK was involved in the
original
original case.
Action, a criminal penalties action where there would be a jury trial, right? Or bring cancellation proceedings where the manufacturer would get to defend itself in a formal adjudicatory process with cross-examination and calling live witnesses, the kinds of formality, again, even in the old regime, that would have been required before you give agency action the force of law. You said in Menson you're not going to play a mousetrap game to create impossibility. You're not going to benefit plaintiffs by saying, well, you could have gone to the FDA and sought pre-permission or approval, and they might have said yes. You shouldn't play a mousetrap game for the other side either. They shouldn't be allowed to say, well, we didn't even try to amend our label, which we unilaterally could have done. But if we had, the EPA might have told us no, and they might have brought these cancellation proceedings, and they might have then won those proceedings, and it would have stuck in court. That's too many links in a causal chain for impossibility analysis to apply. I also think we could talk about the regulations that my friend on the other side.
Before you do that, can you just speak to AF2 and the clause that talks about not being a defense?
Yes.
Mr. Clement indicates that that's not a defense to an EPA action. Is that your understanding as well?
This is my moral argument, not my legal one, but I'll be real. I think anytime there's a risk, there should be some sort of moral duty to warn.
Shall this be a defense to any violation of FIFRA? Obviously, that includes any of the definitions of misbranding. You can see the offense in 136JA1E, which defines any misbranded sale as a violation of the statute. He wants to reread 136JA1E to say Any misbranded pesticide is really just a pesticide that doesn't use the label.
Well,
that
RFK's
EPA
been selling
approved
his soul
at
since he joined the
registration.
Trump
That is not a
administration. Nobody
possible
should be
reading of
shocked.
any misbranded pesticide,
If
particularly
he had
given
one to begin
paragraphs
with,
B
which
and
is a bigger
C.
question.
So if you want to follow the statute, it's at page 40 of the red brief appendix. Congress knew how to lock in place information from the registration statement. Paragraph B says you can't sell even a registered pesticide with claims made for it, different than the registration statement. Paragraph C says you can't sell a registered pesticide with a composition different from the registration statement. If paragraph E were really meant to just be you can't sell a misbranded pesticide and the definition is the label departs from the one in the registration statement, of course Congress would have used a parallel formulation, but it didn't. So I think 136 AF2's first sentence can't possibly bear the meaning that he's suggesting. He also suggests, I believe, that 136 AF2's first sentence is not in itself the thing that he's using as the defense. He says it's not registration alone, it's registration plus the EPA's findings of safety at registration. That doesn't make any analytical sense. He's saying that the EPA has to consider safety at registration. So he's saying it's no defense by itself, it's just a defense if the EPA does the job that he says they are statutorily required to do, and then it's a complete defense. That's adding a lot of words to the statute that I don't think bear the plain meaning.
Your friends on the other side rely heavily on Regal, and they did in their opening briefs. And in the reply brief, they say, well, you just mentioned it.
Roberts has been mouthy today. I'm not even going to lie.
I wonder if you want to give a fuller exposition about why your case is different than Regal?
Of course, Mr. Chief Justice. I thought our 3 paragraphs at the end of the brief were persuasive, but let me hum a few more bars on that score. So first, there's nothing like 136 AF2 in the medical device amendment. So that's a huge distinction. 136 AF2, again, I think is making very clear that registration doesn't have the effect
it's probably a
that
June
the medical
decision.
device amendments do. Second, in Regal, you found as a matter of the statute, not as a matter of regulation, we didn't have to ask a Loper-Bright question, as a matter of the statute, that once the FDA approved the medical device, you couldn't depart from the label. So that's an obvious distinction. And then finally,
I love
even then,
when they call in
the
recent
option
cases.
of a parallel claim. In the penultimate paragraph of the opinion, you said, we're not going to address whether a misbranding claim could proceed here because there is an obligation under the Federal Food, Drug, and Cosmetic Act to not sell a misbranded device. Stop selling is the duty. Ms. Regal might have been able to pursue that sort of claim, but she raised it too late. We're a court of review, not first view, as you said many times, so you're not going to address it. So you left open the question that's not open in FIFRA because you have Bates, and Regal didn't overrule Bates sub silentio.
I mean, just to be simple-minded about this, Mr. Keller, you have a preemption provision that's labeled uniformity, that's clearly designed to achieve uniformity in labeling. And what uniformity would your regime achieve?
Uniformity in law. So I believe that the express preemption clause is requiring uniformity in law. The law of Missouri and the law of the United States have to be the same. They can't be in addition to or different from each other. So it is truly requiring parallel law. It does not require fact finders to find the facts the same way. So the law of the United States and the law of Missouri could be the same. One jury could say, Monsanto didn't do it. There's nothing wrong with this pesticide. Glyphosate is totally safe. There's no breach of duty. That's not a preemption question. That's a question of breach of duty, and a different.
You got a whole jury in Missouri to be like, "Fuck that
Congress
shit."
could, of course, write
that
a
should
different
say a
express
lot.
preemption clause. Monsanto is lobbying literally right now for Congress to do that, and if they are successful through the bicameralism and presentment process, we would begrudgingly concede that these state claims would be preempted. But that's not the law Congress wrote.
You think it's uniformity when each state can require different things?
I don't think each state can require different things. The law has to be uniform. So if Missouri law was in addition to or different
it's
from.
the label's illegal in one state and legal in another state. That's
Kavanaugh.
uniformity?
I don't agree with that. The label's not illegal in one state and legal in a different state. A jury has found the facts to say.
The label subjects you to liability in one state and does not subject you to liability in the other state. Is that uniformity?
I don't think it's state by state. I think it's jury by jury. You noted in Bates that despite the government's claim of a cacophony or a patchwork or a crazy quilt, that's just the consequence of our civil jury system where you have individual cases or controversies.
I agree with you, absent a clause that says uniformity in federal law.
Well, it says uniformity, but uniformity is the caption. What does the actual text of the uniformity clause say? It says you can't have any requirements for labeling in addition to or different from those required under FIFRA, and the requirements for labeling are those supplied by the misbranding prohibitions defined by Congress in 136 subsection Q. So as long as Missouri mirrors those requirements, Bates says a requirement is a rule of law to be obeyed. So if Missouri law and federal law have the same requirements, it's not in addition to or different from.
If they changed the label from what EPA had said, would they have been violating federal law?
So no, this goes more to impossibility. I agree with Justice Barrett. In this context, I don't see how impossibility and express preemption can come out differently. You have cases like Geyer where you say you can still go on to implied preemption, but here it requires parallelism. It can't be in addition to or different from, so they have to be the same. Justice Thomas, you've talked about—
Just to go to my question, if you could.
Apologies.
Under federal law, if they do a different label than what EPA has approved, would they be violating federal law?
No. I think I win that 3 different ways. I don't think the statute prohibits a label change. Look at 136J. There's a long laundry list of prohibited acts. Changing the label unilaterally is not on that list. We've already talked about 136 AF1. I don't think that there's anything there that—
So the Solicitor General's wrong about that?
Yeah, very respectfully, yes, he is. And you don't give deference to the Solicitor General in interpreting FIFRA. You look at the words for yourself. So yes, the United States is wrong about that. Then they go to the regulations. They quickly jump to the regulations.
That was a banger.
What's the source of authority for those regulations? If you ask the EPA the source of authority for those regulations, I kid you not, it's 136 to 136Y. They cite the entire statute. That's their source of authority.
I enjoy a spicy attorney as long as they are not getting spicy with the judges, because that's just dumb.
Again, maybe in the Chevron regime, we might have looked past that. But we're in the Loper-Bright regime. I think you need affirmative text
Well,
before
Mr.
they can
Keller, did
regulate.
Loper-Bright say one word about preemption?
No, it doesn't. But
Loper-Bright is about the relationship between 2 branches of the federal government, right?
Well,
is that a fucking
I agree with
Alito?
that. I think it is always a separation of powers issue if you're going to ask whether the executive branch gets to pronounce what the law is instead of the judiciary. And then, of course, that's relevant in the preemption context.
Why is it relevant? Preemption involves the relationship
Yeah, it's
between
fucking
the federal
Alito.
government
He makes
and the
me
states.
stabby.
It does, and under the Supremacy Clause, federal law is the supreme law of the land.
He has been
what
on
counts
one all
as
day,
federal
chat.
law
If
is
you were
relevant
just
to every
joining
preemption
on
inquiry.
one
I would
all
be
day.
surprised if Loper-Bright were somehow cabined and not applied in preemption cases where a regulation is doing the work to create preemption. You have the separation of powers problem plus a federalism problem because you're letting the executive, not Congress, preempt valid state law. That should only be done pursuant to a valid
Your
delegation.
prescience about where the law might go is interesting, but it's not there now, is it?
Well, I think that that's what you meant in Loper-Bright. You all know better than I do what you really meant in Loper-Bright. But I think a rule that says the Loper-Bright regime is cabined to separation of powers cases and doesn't apply in preemption cases, I don't think makes analytical sense. You could draw that line. You've drawn lines before that maybe previously didn't occur to me that subsequently emerged. So I'm not going to tell you couldn't do it.
You think that would be an irrational line to draw?
I do.
Hey, Palpable, I'll bring you up as soon as this argument is over if you're cool with that.
Who decides what the law is? Is it the judiciary or is it the executive branch? That is obviously relevant to preemption questions when we're trying to figure out what the law
It should probably be over pretty soon.
Well, Loper-Bright didn't suggest that Congress
Although I don't want to
couldn't
shoot myself in the
delegate power
foot.
to agencies.
I agree.
And it seems here as though there's a pretty big delegation of power to APA.
I agree.
To figure all these matters out.
I agree there is an important set of delegated powers to EPA. And there are many that we haven't discussed that I do think would create labeling requirements. But the registration provision of 136A, which is where
Capable.
I just
are palpable. I just work here.
Is this broad delegation
Law's
to
my
ultimately
boss.
decide whether a pesticide is misbranded or not. I agree with you, though.
I'm just a
There are,
paralegal that likes
express,
SCOTUS nerding.
Delegations of authority that I do think could create labeling requirements. I can give you 136WC2.
Well, I mean, if we just sort of think about this scheme, right, it says to EPA, you have to do this big study, you have to weigh costs and benefits, you have to figure out on the basis of
this
that
is Kagan,
whether
by
to
the way.
register a pesticide. You have to do that again every 15 years. You have to keep track of things in the interim. You have to, take seriously further information that industry gives you after registration. It just seems like a lot of stuff that the EPA does and is told by Congress to do to ensure the appropriateness of a particular pesticide.
I completely agree with you. FIFRA is structured in a way to maximally protect the consumer. So selling an unregistered pesticide is the first offense in 136J, but you also can't sell a misbranded pesticide. And so
I'm
regardless
hoping
of what the EPA
he does
says,
another
they are not
one
a safe harbor. They don't
when we
get
get
to announce
some
for you
sort
by
of
registration
returning
all of
documents,
those
like
other
a what the
provisions
fuck are
to
you
protect
talking
the
about
consumer
from
these dangerous
SPLC? I'm
products,
here
which
for
by
it.
definition kill living organisms. They just don't have that blanket immunity. I agree that EPA has all of those obligations, and though I think there are a lot of conscientious people working at that agency, I think we should also all agree that
My
things slip through
assumption
the
would be we
cracks
get
with
some
that
time this
agency. They were a
week.
decade behind schedule in their re-registration of Roundup, only to have their findings regarding human health vacated by the Ninth Circuit in a decision they don't challenge. So the last re-registration that we have is 30 years old, 1993. It would also probably not surprise you if they're not constantly keeping abreast of all of the annual reports. You've said similar things in the Food, Drug, and Cosmetic Act context, where there's a lot more rigorous upfront data.
Who's running the EPA with
phase 3
dipshit
clinical
in
trial
charge?
data is given to the FDA. And even there, the FDA agrees that post-NDA application, post-approval, you can still have a misbranded drug. It shouldn't be less protective of consumers under the context of FIFRA, where the EPA is operating with less information.
On those points, can you speak to the petition process that
Kavanaugh.
the petition to change the process where you go to EPA and say there's new science, you're behind the times, everything you just said? I thought there was a process you can go to EPA, but I want you to address what you think of that.
I actually think Ms. Harris said it exactly right. There is a process by which citizens, and I'll confess, I don't know if states can as well, but I'll take her word for it.
You know
that states
what?
can also
Harris
go
may
and
have
say,
been
you shouldn't have re-registered this pesticide.
who I'm thinking of,
and
who
there can be a
did
formal
the
process.
Solicitor
agency, of
General
course, would
argument,
get
and it's not the
deference, but there is
Hamani case, it
judicial
was the
review
other gun
under, I
case
believe,
we heard.
136A.
We were talking about black
Are there
codes.
any labeling and packaging
She was good,
requirements
like
under this
admittedly, I don't give a
chapter,
lot
in
of
your view?
glaze to Solicitor Generals, but she was good.
136WC2 is a good example of an interaction between what the agency does and labeling requirements. I think you can find that at page 48 of the red brief appendix. So 136WC2 invites the EPA by notice and comment rulemaking to designate a pesticide highly toxic to man. That designation creates labeling requirements because a highly toxic pesticide is misbranded if it doesn't have the skull and crossbones on the label, or if it doesn't have poison in red letters. That's 136Q2D. So if Missouri law said put poison in purple letters, it would be preempted. If Missouri law said don't scare consumers with the skull and crossbones, it would be preempted, and it would be preempted under FIFRA because it's the operation of the misbranding prohibition in conjunction with a valid delegation of authority. Congress knew how to delegate authority. The danger caution example in Bates is another one. 136A subsection D is where there's an express delegation to regulate, to create signal words on restricted use pesticides. So even though Bates didn't go into a long discussion of where that source of authority was, again, we were in the Chevron era, so it didn't have to, there's an actual delegation. Congress knows how to delegate this authority.
Wolford v.
It didn't through the
Lopez, that's the
registration
case I was
process.
thinking of.
Thank you.
I'm happy to cede back time.
Justice Thomas? Justice Lee? Justice Jackson? Okay. Thank you, counsel.
Rebuttal.
Mr. Clement?
Thank you, Mr. Chief Justice. Just a few quick points in rebuttal. My friend started with Bates. Bates really is distinguishable because it was mostly talking about efficacy and went out of its way to say safety is different. You can sort of think that in some respects Bates is like Lohr to Regal. Lohr said 510Ks. We really don't do a lot, so we're not focused on that much. There's nothing there to essentially have preemptive effect, but pre-market approval in Regal was different. I think it's the same with respect to efficacy and safety. On Regal itself, my friend offers two distinctions. I don't think either of them works. First, he says there's no equivalent to F2, but even without the equivalent of F2, nobody in Regal thought that just because you got pre-market approval, that didn't mean you couldn't possibly mislabel your device if you used labeling that was different from what was approved in the pre-market approval process. So F2 really doesn't do anything that wasn't already implicit. And then he also pointed to, he said, well, there's a statutory provision there that said that you can't change the labeling. If you look at the provision Justice Scalia cited there, you'll see that it's very analogous
They want
to
the Fed
the
when they
F1
want the
provision
Fed,
that
and they want
basically
small
says
government
you
when
can't
they want
change the
small
label. And you have to read the whole
They
sentence,
can't
because at the
decide.
end it says without the approval of the agency. So Regal really is parallel here. The possible difference is there's still more open in this regime because you can have design defect claims.
But Paul
you can
Clement
have
has
states,
done
if they
some
really want to
good
say
pieces
you
too.
can't
I don't
use
want
it,
to.
states
I don't want
have
to
options
singular
that they
hate
didn't
on
have
him. He's done
under the
some
medical
really good
device
ones too.
amendments. So let me just finish with uniformity and practicality. On uniformity, it's worse than 50 states. It's every jury is a new day. And I checked, uniformity is a title, but it went through bicameralism and presentment just like the rest of the statute. So I think you have to take that seriously. Finally, just on the practicalities of this, if you tell any one of those juries that this fancy-sounding international association on the research of cancer found a hazard warning for glyphosate, that sounds
Oh, he
pretty
did
bad.
not just go
But
there.
every
Now I want to
agency
smack him.
around
I
the
just
globe,
glazed
New
you,
Zealand,
Clement.
Japan,
Don't make me come for you.
Australia, the European Union, Canada, they've all looked at glyphosate. It's probably the most studied herbicide in the history of man. And they've all reached the conclusion
findings are
based on more
inconclusive
data
before
and
you
the kind
sit
of
here and
expert
say
analysis
they've all
they can do
reached. Shut the
that there
fuck
isn't
up.
a risk here. You shouldn't let a single Missouri
No.
jury second guess that judgment. Thank you, Your Honor.
That's not
Thank
what
you,
is a
counsel.
card.
The case is submitted.
All right. Law may still be in Zoom court. I'm not sure. That was a lot today, guys. That was a lot. So go back to the first case. Geofence warrants are interesting. I think I'm going to say I don't know what way they're going to go on that because it was sort of like all over the place, if you will. I kind of thought that they were vibing on the U.S. side more at first, but then I saw the questions, and that attorney, the Solicitor General, was so rude and pissy. And I'm not saying that that should or does affect arguments, but I'm saying it sure doesn't help you get where you want to go. If you want to do something, don't get pissy with the justices. That's just a bad fucking move. And Gorsuch was heated. He was not feeling it. Roberts got a little sassy too, and I love that. I love a sassy judge. In fact, the judges that he was the most rude to, which were women, were just like, they just kept right on rolling. They did not give a fuck. Like, he was all blah, 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 blah. And then they were like, okay, but let me ask you this. Like, they had no cares to give. But Gorsuch was funny in that case. I honestly don't know what that way that's going to go, but I can say the government did not do themselves favor in this case. Now, this one is weird. The Monsanto case, definitely not my background. Some of it I could not follow because torts, things like that's just not anything I have some sort of like vast specialization in. But what I will say is this, they asked some good questions. I think at the end of the day, I just want to see where it goes. It's more of an emotionally invested thing than I was legally invested in it. Because like I said, I have family members that have, well, according to Paul Clement, just wound up with cancer associated with, glycophosphate, but, that wasn't anything to do with it. But whatever. I don't know what way they're going to go with that. That was certainly, I'm going to have to read SCOTUS blog's take on that one. First one, though, the one I was more invested in, I don't know. I don't think the government did themselves a lot of favors. And I think by the end, vibe-wise, they weren't feeling the government as much as they were feeling the other side. Also, that attorney made some really good points, super respectful. Like, my hat's off to him. We had the Solicitor General Harris in this Monsanto argument. And to be frank, I've seen a lot of government Solicitor Generals. Most of them suck. She's actually pretty good, and she did really good in, I believe it was Wolford v. Lopez. where she did some, sorry, I can't even think right now. They did some arguments in that. But here's what I'll say. I've been on like 3 hours. Law is probably still in Zoom court. So I love you, Law, for being here. You're the bestest. But I'm going to go ahead and get off. If you have questions or think of anything, DM me. I'm going to try to start making more content for y'all, doing more lives. If you're Frank Law's team, I guess so. Look, I'll say this. I want to start doing more live content for y'all. I've been trying, and I know there's not a lot of people in here right now, but if you have any case, it doesn't have to be a Supreme Court case, even if it's just like, I'm going to be following the David case because I'm interested in that, and there's a few others. If you have any cases that you would like me to cover or go through, even if they're just a state court thing, send them to me. I'm happy to look into it and go into them. Yes, on my page in my link tree, I have a YouTube where I go through the oral arguments on birthright citizenship. Now, if you don't want to listen to me talking, that's absolutely understandable. You're more than welcome. You can go to the SCOTUS website and go to their oral arguments, and you can find it's Trump v. Barbara. But it's also listed that way on my YouTube if you want to watch that one as well. Victoria, DM it to me and just tell me the name and just give me just like a tad bit of background, because sometimes people have similar names, so I don't want to sort out cases, but you can certainly send me a case. I am happy to do it. I usually try to get them done within a week, but I want more people to send them to me. If there is a case you're interested, I don't matter how little or small it is, send it to me. We'll go through it, and I will tell you the day that we're gonna go through it. That way you know for sure. But anyway, everybody, I'm sorry. I've just been on so long, I'm exhausted. But thank you so much for being here. Feel free to DM me a case. I do have a YouTube. I also have Law's Discord that I'm in as well. I use that as my Discord. You're welcome to join. And everything is in my link tree. And if you need anything, just let me know. I love all of you. Thank you for the love and support. You're amazing. And y'all have a good day, guys.